welcome you to the annual conference 2023 of Direct Taxes Professional Association DTPA. The theme of today's conference is Navigating Economic Development, Expectations from Professionals. Our conference for the day is split up into 4 sessions. We start with the inaugural session and then proceed directly to the first technical session. Thereafter we break for a lunch and then assemble at 2:15 for the second technical session. This is followed by the panel discussion. During the day we shall have the privilege to hear the words of wisdom of our experts, and I'm sure all of us present in the hall will have a lot to take back when we leave this conference. Now I request our President CA DS Agarwal and CA Sanjay Bajoria, Chairman Conference Committee, to escort Honorable Mr. Justice Rajesh Bindal, Judge Supreme Court, to the dais for the inaugural session. I also request CA NK Goyal, Co-Chairman Conference Committee, CA Vikash Parak, Co-Chairman Conference Committee, and CA Manjulata Shukla, Secretary DTPA, to join the dignitaries on the dais. I now request everyone to please rise for the national anthem. Jaya Hai, Jaya 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 Hai. I would now request our Chief Guest Honorable Justice Rajesh Bindal, Judge Supreme Court, to inaugurate our conference by lighting the lamp. I request the others on the dais to proceed for the lighting of the lamp. I also request the chairman of the first and second technical sessions and the speakers and the panelists in the audience to kindly come forward for this ceremony. I now request CA DS Agarwal, President DTPA, to deliver his welcome address.
Honorable Mr. Justice Rajesh Bindal ji, Judge Supreme Court of India, distinguished guests, speakers and panelists for the day, officers from various government departments, ERC Chairman Jayan Pata and his team, past presidents of DTPA, fellow members, ladies and gentlemen. With immense pleasure and a profound sense of honor, I, on behalf of DTPA, extend a very hearty welcome to all the dignitaries, distinguished guests, and learned speakers and panelists from across the country for taking time out of their busy schedules for sharing their knowledge and wisdom with us today. I also welcome all the members and other delegates for being part of this conference. Friends, it's your presence that provides motivation and energy to Team DTPA to organize events throughout the year. DTPA has evolved over the years as an association committed to its motto, Jnanam Ekya Nyartham, which means knowledge and togetherness for justice. with a great history that spanned 41 years, our association is recognized as one of the premier body of professionals consisting of more than 1,800 members. I am deeply honored to welcome Honorable Mr. Justice Rajesh Bindalji for kindly accepting our humble request to grace and inaugurate this conference as our chief guest. His august presence is a matter of great inspiration, and his words of wisdom will help a lot to the professionals in contributing their skills for the development and growth of our country. I would also like to welcome and thank our support partners, members and others for their contribution and connecting with the association. I also welcome our media partner and friends from the press. Friends, just as a navigator guides a ship through uncertain waters to reach its destination safely, navigating economic development involves steering an economy through challenges and opportunities to achieve sustainable and inclusive growth. This process requires the coordination of various stakeholders, and because of our expertise in financial management, auditing, compliance, strategic advisory services, and so on, expectations of such stakeholders, which include government agencies, businesses, educational institutions, society, and international partners, have increased manifold. Keeping this in mind, we have organized this annual conference 2023, which is a flagship event of our association on the theme Navigating Economic Development, Expectation from Professionals, which encapsulates the pressing need to address the challenges and opportunities that lie before us. As professionals, we bear a unique responsibility in charting a course that not only leads to economic growth, but also upholds ethical standards and societal well-being. I am confident that today's discussions and deliberation will shed light on innovative pathways and strategies to achieve this delicate balance. Our conference will consist of 2 technical sessions and a panel discussion. The technical sessions will cover current pertinent issues in income tax, GST, and capital market, to be deliberated upon by eminent experts, which include Senior Advocate Abdul Majumdarji, CA Jagdish Punjabi, Advocate Bharat Rai Chandani, CA BL Mittal, and Sri Ajay Bhagwa. The panel discussion focuses on the theme bridging expectation gaps, do's and don'ts for professionals, and the panelists are CA Niharan Jambu Sangha, past President ICI, CA Priya Ramesh, CA Shailesh Haribhakti, and CA AP Singh. The session will be moderated by CA Dr. Devashish Mitra, immediate past President ICI. On this occasion, friends, we will also release a souvenir and publication on income tax case studies. This souvenir contains articles from various eminent authors on topics of professional significance, and the publication contains very pertinent concurrent queries on income tax provisions with possible remedy. I am sure you will find the same useful and informative. I would be remiss not to acknowledge the unwavering support and guidance of our past presidents. Your leadership has been instrumental in shaping the trajectory of our association, and we are grateful for your continued support. I express my gratitude to Sri Sanjay Bajoria, Chairman Conference Committee, Sri Nand Goyal and Sri Vikas Parak, Co-Chairman, IPP Advocate Kamal Kumar Jain, Office Bureaus, Executive Committee members, Chairpersons and Co-Chairpersons of Conference Committee, and other Conference Committee members for their constant inputs, efforts, and guidance in organizing this conference. Finally, I thank all the delegates for participating in this conference and hope that you have benefited from the same. Thank you.
Thank you, President. We have with us Honorable Justice Rajesh Bindal, Judge Supreme Court of India, as our chief guest. Justice Bindal started his legal journey as a lawyer in the High Court of Punjab and Haryana and thereafter also appeared in the Supreme Court. He became a judge in the High Court of Punjab and Haryana in March 2006. In November 2018, he was transferred to the High Court of Jammu and Kashmir. In January 2021, he was transferred to the High Court at Calcutta and thereafter was elevated as the Chief Justice of the Calcutta High Court in April 2021. Subsequently, he moved on to become the Chief Justice of the Allahabad High Court in October 21, and in February 2023, Your Honor was elevated as a Judge of the Supreme Court of India. I request our President CADS Agarwal ji to present a shawl to our Chief Guest, Honorable Justice Rajesh Bindal. CASK Sultania ji, past President DTPA, to present a memento to our Chief Guest. Thank you, sirs. Navigating economic development, expectations from professionals. The theme for today's conference is very relevant in the current scenario. I would now request CA Sanjay Bajoria ji, Chairman Conference Committee, to deliver the theme address.
Good morning. Honorable Mr. Justice Rajesh Bindal, Judge Supreme Court, distinguished guests and officers from various government departments, EIRC Chairman and other members from EIRC, speakers and panelists for today's conference, ladies and gentlemen. On behalf of the Direct Access Professionals Association, I take immense pride in welcoming the honorable guests, eminent speakers and delegates to our annual conference 2023. This conference strives to bring together academics, professionals and government representatives to discuss cutting-edge issues in taxation and other current issues. This year, the theme of our conference is Navigating Economic Development, Expectations from Professionals. The broad range of attendees today will, I am confident, provide insights from their unique perspectives on how professionals can be responsible financial stewards of the national economy. The Indian economy is finally redeeming its tryst with destiny. In 2023, India overtook traditional powerhouse France and the United Kingdom to become the 5th largest economy in the world in terms of GDP. This year also witnessed Indian stock markets outperforming historically larger markets and achieving the 5th largest market cap in the world with a market cap of $3 trillion plus. At this crucial juncture, we felt it essential to review the situation of taxation in the country. In particular, 3 issues are central to the role of professionals in driving the sustainable growth of our national economy. Firstly, the recent judicial trend of emphasizing substance over form in tax litigations has meant that courts are able to look beyond the technical veil of transactions and examine their underlying substance. This opens up possibilities for fairer and more equitable outcomes in taxation cases. However, while courts have played a progressive role in tax litigation through this approach of substance over form, the legislature has started using retrospective amendments in tax laws. This is worrying as it poses serious questions about legal certainty, predictability, and fairness, all pillars of the rule of law. Lastly, we hope the conference will spur a healthy conversation about the reopening of tax assessments by tax authorities. While tax authorities need powers to ensure tax compliance, a healthy business environment necessitates a fair balance between these powers and the rights of taxpayers. The potentially arbitrary reopening of tax assessments again poses problems of legitimate and expectations for taxpayers and impinges upon the transparency and foreseeability of tax laws. And as I'm sure we all can agree, the rule of law is essential to providing the stability required to spur investor confidence and promote a healthy business environment. As a result, we have carefully curated a set of sessions with some of the sharpest minds dealing with issues in different fields. I sincerely thank President DTPA CADS Agarwal my co-chairman CA NK Goel and CA Vikas Parekh, Vice President CA Rajesh Agrawal and CA Barkha Agrawal, Secretary CA Manjulata Shukla, Treasurer CA Shyam Agrawal, all committee chairpersons and co-chairpersons, committee members and past presidents for their dedication and support for making this conference a reality. I also thank the contributors for their support for the conference. Last but not least, I thank the delegates for their active participation. Thank you.
Thank you, Chairman, sir. I would now request our Chief Guest, Honorable Justice Rajesh Bindal, Judge Supreme Court, to kindly deliver his address.
A very good morning to all present. What I see on the dais is Mr. D.S. Agarwal, President of DTPA, Mr. Sanjay Bajoria, Chairman Annual Conference, Vikas Parekh and Mr. Narendra Goel, Co-Chairman, Rajesh Agarwal ji, Senior Vice President, Ms. Manjula Shukla, and in the audience I am seeing, because I was at Calcutta for about 9 months, Mr. Majumdar and Mr. Trivedi, they were there in court. Regularly we had interaction in court basically. All other chartered accountants, company secretaries and professionals who are present here. First of all, I am thankful to the Direct Taxes Professionals Association for inviting me, because you see I spent 9 months of my career as a judge at Calcutta, and wherever you live for some time, that becomes a home basically. So that's why I could not say no to the invitation, though I had some other engagement, but that had to be postponed. So it was. And the idea was also because whenever I go to any conference, so what I think is the idea is to teach me more, and my eagerness to learn basically. May not be in the session because I may not be attending the session, because a lot of things we learn just by interaction also, that what else is going on. There are a lot of things which are not shared in the court as such during the course of arguments. And many things in informal discussion, like yesterday we were having the dinner and all that, so a lot of interaction is there. So that also is helpful in discharge of our duties, because law is not that way static, what is the letter of the law, because the society also has to be seen, the things which are changing are to be seen. What I was told, and I read it, the association was set up in 1982, 41st annual conference, and large number of members, 1845, consisting of CAs, chartered accountants and IC and the cost management accountants. A good combination, because these are all related issues. And another feather in the cap is publication of e-journal now, because we are going e-way only basically in all areas. There's the blessing of COVID, though there had been many negative issues also. Technology has in fact taken over, but you have seen the example of technology here. We should not be dependent. Now we failed in Jan Gan Man only, national anthem. So this is, technology can fail you also. So we should not be dependent on this. So we could all be together and then recite that. So that has to be the spirit. We should not rely on that. And in the e-journal, what I saw, because the copy was given to me, there were a lot of amendments which were there, latest case law also, articles also. They say, good idea to keep all the professionals updated, because many times during your professional engagements, you don't get time to study different books. It's a compilation of all, easier. Like a reporter monthly reporter used to come to us. You just have time and glance that, and you come to know what is going around. Now technology has taken over, a lot of apps are there, they also continue pushing a lot of stuff. But in any case, we have to be updated on all these things. Regular conferences, yes. Study circle meetings, that's also good. should be there, but what my suggestion is, because I have not attended the session, it should be kind of a dialogue basically, interactive sessions. Not kind of monologue only that somebody is giving just an address and all that on some issues. Somebody may have doubt also on that. Let all the audience clear their doubts also. The time should be given for that. Because if you have monologue basically, the intake may be 10 to 15%, 20%. But if you have dialogue, maybe I have a question. I am feeling shy to ask that question. Somebody else may ask that question, so that clears the doubt of many of the people in the audience. So that should be the idea. And what I found that in the trainings, there was training for staff also and technology also, which is really taking over now. So that's a good thing. And one thing more I found in the documents given to me, that the space for the office and conferences has been given in the office of the Income Tax Department. That's a great thing, I think. Otherwise it's very difficult to get even the refund from the department. You got this space also. That's a great achievement that we could get something from the Income Tax Department. Now, motto of the association I was reading, Jnanam Evam Cha Nyartham. Knowledge and togetherness for justice. Yes, we can get justice to our clients and state, of course, with all of us being together. Because we are kind of a bridge between the state and your litigant, the client. It's not possible, implementation of tax laws or execution thereof, I think, is not possible without the professionals being there. So their role is very important in this. I congratulate this for this conference to the association. And another important part is, just see the futuristic name. Name of the association was, I think somebody thought of in 1982, Direct Taxes Professionals Association. If we see now, probably most of the taxes are direct only. The stage of sales tax is gone where there could be first stage levies, so nobody knows how much tax has come in. Nobody knew how much excise is there in any product. Now it's all consumer based. In the bill only you get the tax, how much you are paying. Income tax is naturally direct only. So practically it's all direct taxation, which somebody sees how much I am paying. The time has gone that you never knew how much is their tax effect in any of the products you are buying. Maybe you are buying a car or a luxury item. There are a lot of taxes, only finally maybe 7, 8%, 10% sales tax you used to pay. Or the first stage levy, first stage the tax is gone, thereafter it's tax free. So nobody knew. Now you know how much taxes you are paying. That was the, I think, income tax also, direct taxes. So that was, I think, maybe thought of in 1982 about all this. The program is in Calcutta, association is in Calcutta. We know it's a commercial and financial hub of the East. And the East India Company also started from here only. And this place is important because I think it was the capital of the country from 1773 to 1911. That is there. But one positive part is that now that company is owned by an Indian only. In 2005, Mr. Sanjeev Mehta, which I read, he purchased that company and is working in UK now. Some outlets he has opened, trying to be positive about the name, because otherwise we have some negative feeling if we read that name. Another thing which I read about the Bengal only, not the city of Calcutta. There are only 12 people in the country who won Nobel Prize, and out of them 3 were from West Bengal. It's a great achievement, 25% throughout. One and 2 were in economics only. One was Abhijit Banerjee and another is Amartya Sen, we know it. Abhijit was granted long back. And in literature, Rabindranath Tagore, we all know, we live by his name. So rich culture and heritage here. I think we should bring back that glory which was there in Bengal and city. All of us have to be together. Now, theme, navigating economic development expectations from the professionals. We can't think of any economic development unless the professionals are there, because we all know that major source of revenue are the taxes only. If we see 23-24 budget projections, 27.20 lakh crores are expected to be the receipt, and the tax is 23 lakh crores out of it. So it's a major part of share. And now we all know some details have been given about our economy in the last 4 or 5 years or 10 years. Our Prime Minister says we have to be $5 trillion economy in next 3-4 years. So that will be possible only if our business grows. If business grows, naturally the revenue in taxation and private persons also grows. Similarly, if you see the GST collection also robust, going on in 2023, more than 1,60,000, 1.60 lakhs per month, and last month was 1,65,000, though April was 1.87. And I can share that in 2017 this act was brought in. So there were a lot of issues. So they interacted with the judicial system also, that new law is coming, a lot of changes are there. So some programs were kept. We have our judicial academy at Bhopal, National Judicial Academy, where the judges throughout from the country, High Court, District Court, all levels go. So they proposed a program for the judges also, so that they can share the principles and the ideas behind that. So in 2017, I also attended that. The persons who were in the drafting committee, they also admitted that because this act has been framed in a hurry, the deadline was there, I think, in September, because otherwise thereafter no tax would have been there because of the constitutional amendment, that there are some errors in that, in drafting. But at that time, 17, but they were expecting if the revenue is about 1 lakh crore per month, they would be happy. But I think it is going robust. And maybe one reason can be the technology in that. And second important reason is, I think, the guidance of the professionals only. This is how you play a big role in the economy. And what I think is, initially the union government had promised that if the states don't have 20% per annum additional collection every year increase, so they will contribute. Probably no contribution was required by the central government because the state also generated revenues more than that. Now income tax also, from the last year to this year, 2023, the collection was 16.61 lakh crores. It was more than 17% increase from the last year. It was not possible without contribution by the professionals, their proper guidance, and also, yes, business is improving in the country. The corporate tax growth I could find was about 17%, and the personal income tax was 24%. But still the major area remains the salary only, if you see. But another data which I was seeing, that the number of returns, income tax returns filed in this year was 6.81 crores as against 5.83 crores last year. And this is an increase of about 16 to 17% from the last year. But the fact remains that out of this, about 4.65 crores are only either no tax or up to 5 lakhs return. So means no tax basically. But another positive side which I could see was that from 21-22 to 22-23, the increase in the returns filed with more than 1 crore as income was from 1.14 lakhs to 1.69 lakhs. So that is the positive part. But still this number doesn't match if you see the society. I can share with you that in Chandigarh there were some applications invited for designation as senior advocates. A lawyer having very good practice, good house, everything, all facilities, and his return before that application was filed only 3 lakh, 4 lakh rupees. Immediately, because the requirement was 10 lakhs at that time, so he immediately next year increased to 10 lakhs because senior designation was required. So there are a lot of such things, but I think this mindset is changing now with the passage of time. And another thing which I found was that in the number of filing of returns, Bengal is in top 5. That's another positive point in Bengal. So that means we have lot of work also there for the professionals. It's in the top 5 states where the number of returns are filed. And cost of collection is also going down gradually. Maybe with the use of technology, maybe staff, you know how it is there. So this is how we are moving ahead. Another positive point where the role of professionals is there and it is going on, and in future also it will go, is there is a lot of voluntary compliance now. This is a positive direction, I think, positive trend. In the form of TDS, advanced tax or self-assessment, these are 3-4 kinds basically, for example I am giving. So out of 16.36 lakh crores in 21-22, about 94.5% was by voluntary compliance. The assessment was only 5-6%. So that is not possible without the guidance advice of the professionals who are guiding them. So this is a positive part. And another thing which I found in data was that there is a trend of, now we say indirect taxes like GST is the main thing, towards that only. As compared to earlier, the direct taxes were probably more. And the reason for that may be because of the widespread levy GST has. There are a lot of people who are paying you GST, were never there in the income tax net and may not be there. Like you see the street vendors also, they are also having the mobile. They may also have some scooter or something for insurance. Small things they are using and they are also paying GST, maybe at a lesser rate for your necessities, but still they are also contributing, otherwise they were not contributing towards your income tax. Now, for laws, you can always see they are all complicated. We all know the Income Tax Act is as old as I am, and there may be thousands of amendments in that till date, and GST is about 6 years. In that also there are amendments and notifications coming on. So keep a track of all of them is really a challenging task. And especially when each assessment year is an independent assessment year, you need to see the provisions of that year only. And but I can share with you that drafting of a law is a very difficult job. It's not that easy. I had some experience of drafting because there was some issue regarding international child removal, because when the couple is in different countries, basically either of the spouse come to other country. Maybe they are here, somebody goes abroad, or from abroad somebody comes here and brings the child. That litigation is increasing like anything. So there is no law, there are international conventions on that. So there was a committee constituted which I was heading, so we had to draft that law. There was already a law drafted by the Ministry of Women and Child Welfare and another by the Law Ministry, but somehow some reservations were there, so there was a committee. So that was a very challenging task, because law can't be drafted as a static document basically. We have to take care of lot of future things which may arise, to visualize. Some plays have to be kept. But still, I think the drafting of laws presently is little poorer as compared to the earlier times if we see the provisions. And you must have read in the newspaper today only, the 3 are old laws, IPC, CRPC and Evidence Act are being changed. Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Bill. Number of sections are being reduced. So naturally people like us now who remembered 302, what 302 is, and everybody knew what 302 is, now the section will be changed to 101. So it will be a great transitional phase in that. And similarly 420 is to 316 or something. So a lot of sections will be changed, because there is in one law some reduction of sections, in another some increase also is there. But just see, direct taxes code I think was planned about 10-15 years back, but it has not seen the light of the day. In this also the idea they say is to simplify. Laws should be simplified, there is no doubt about it. But in the taxation also, because certainty is there, because business will run only if they have the certainty. Huge demands we know all created if the business is set up after 2, 3, 4 years and the litigation takes maybe 5, 10 years thereafter. And some industries, some business may not survive because of that demand if the clarity is not there. So that clarity, certainty in tax laws, I think is required. That should be there. If these laws are also simplified, a lot of issues can be resolved, the business can prosper further. There are a lot of suggestions in those laws also about timelines and all that, but I don't know how those will be achieved, seeing the strength of the judges also, seeing the speed at which our investigating agency or the prosecuting agencies work. But still, a good sign, because if you see the Consumer Protection Act also, there are timelines mentioned that the complaint should be decided within 90 days or something. And it takes 3, 4, 5 years at the district forum only, because of the numbers. No, enactment of law is one thing. In that process, we have lawmakers also, the parliament or the state assembly, they will frame a law. Then execution is with the executive, the department, in our case, the income tax or the GST department. And third, most important part would be the taxpayers, because their pocket is to be indirectly, because for them it is indirect. They are not going to give from their own pocket all indirect taxes. They have to pass on the burden only. And the most important part of that process is the tax professionals. Unless they understand what the law is, they can't guide their clients and they can't implement that properly. Because we all know whenever a new tax is introduced, like on gaming only they say 20%, 28% GST will be there. They say kind of a luxury, but still on that also some reservations had been there. Because gaming is not everybody's cup of tea. Role of the department also, many of us feel that it's not that friendly. Maybe in salary class like we file the return and maybe week or 10 days we get the order also, but not for all of us. And taxpayers naturally, they feel they are being fleeced. So unless the tax professionals guide them properly, probably this system will not work. Because the way tax professional will explain all these issues, all these provisions to the client, he will understand that. There was a conference in Delhi. Similar issues are there. So Justice Dinesh Maheshwari was there. So he had been in Meghalaya, Chief Justice. So he had a very good example of that. He said in Meghalaya you have the root bridges. So that, how strong those bridges are. So this is the bridge between the department and the taxpayer, a very strong bridge of the professionals. So that bridge has to be strong, and then only this all system can work. Because coordination is required, and sometimes a taxpayer may think that the professional is working for the department and not for him, because he may guide him that to pay some taxes and all that. But whenever some amendment is proposed, this is what I think, like in GST they had lot of seminars, lot of meetings with the professionals also to apprise them about the intricacies of that. So whenever any amendment comes, I think they should educate or have meetings. Prior to that also I would say to seek their feedback, how this amendment will work, whether it is good for the business and all that, and how the loopholes are to be plugged. That should be the idea. Because idea of any professional should be that taxes which are due under the act are paid, and not that somebody is fleeced. Because tax planning is good, avoidance is bad basically. Evasion is bad, avoidance is good. So that should be the idea in that process also whenever the amendment is made. But sometimes the amendments are made like that. In one of the programs, some story was told about the amendments, how in taxation laws these are made. They say there was maybe some of you may have heard it, but I'll just narrate, that's a small thing. There was a Baba sadhu kind of a person who was going on his bullock cart with his disciples. So on the way, he had been given a very beautiful and valuable cap by some king. So on the way that fell. But they did not disturb Babaji because he was sleeping. And they moved on maybe some kilometers away. When the Baba got up, he said, "Where my cap is?" They say it had fallen on the way. "Why did you not pick it up?" "We did not want to stop the bullock cart because your sleep would have been disturbed." He said, "No, no, whatever falls down, you should pick up." On the way, then there was a lot of waste or dung of the animals who were pulling the cart. So they started picking that also because direction was now to pick up everything which is falling. So then again he slept and all that, got up, all entire cart was full of that only. He said, "What you have done?" He has followed the instructions. So what happened? Then he said, no. He made 2 schedules, what to be picked up, what to be not picked up. So this is how sometimes the amendments made. You put it in A or you put it in B or something, not thinking what is practical and all that. But one thing important is, which we professionals have to take care is, in lot of statutes, criminal liability on professionals have been put in. That I think we have to be very careful, and we have seen lot of professionals there, but I think long back there was Satyam scam or something where some professionals were involved, but that I think is the area where we all have to be careful. Lot of technology is being used. As we have seen the sample, we should not depend on that, take help of it. In income tax also, in GST also, and faceless assessment, online filing of return, appeal also, everything is there, some positive part, some negative part also, because somebody shared with me that if some assessment or appeal has to be decided of area of Bengal where fishing and all that is there, what kind of expenditure made in fishing will not be appreciated by an officer who is posted in Jammu and Kashmir, because he will not realize the factual things there. Or a person in northeast or maybe in the north, different types of industries which are not there common to the other area. So those practical problems are coming to convince, and there may be a lot of documents in some cases. So those problems are there, but I think this will be taken care of with the technology also, otherwise with the guidance and intervention of the professionals. And with the technology, I think they have been able to take care of the evasion to some extent, because that the figures of collection shows. Now, what I read somewhere was that there were about 40% corporate income tax assessees who were not paying GST returns. This is how they could find from the technology, only from the data they are processing. These all artificial intelligence is being used. Now also, I think today in the paper there was some work from home, some salary they were getting, and then some cash payments they were getting from different persons for doing things. So all those persons are being issued notices now. So there are a lot of issues they are dealing with. They are catching hold of the tax evaders with the technology. Maybe a good sign. You see, the ultimate budget is there, and in budget they plan how to collect and how much tax they have to collect, and then they distribute the levy. If the honest collection is there from all who are evading the taxes, probably the tax burden on the others may be reduced who are the honest taxpayers. So in all, if we all help in that, I think this will be a good idea, and the tax rates also may be reduced if the collection is better and the evaders are brought to book. In technology, we all know, yes, this is being used, but there is a lot of technological divide in the country. We are all not tech savvy. In bigger cities, yes, it may be there, but there are smaller cities also where the professionals are there. During the COVID time also, before that also, when we introduced technology in the courts, we held lot of meetings with all the stakeholders. And in that, judges were there, our staff was there, advocates were there, and then above all of them, the litigants. Because ultimately they are the consumer of justice. They should also know, because all these facilities are being created for them. Yes, system improvement is one part, but the facilities are being created for them only. So we educated them also. We created e-seva kendras in all courts just to facilitate the lawyers also who could not afford and the litigant also to avail of all these facilities. So that kind of facility I think the income tax or the GST department should also have for the professionals, guide them in that so that there are not delays, because many a time it is read that the returns could not be filed on the last day because the server collapsed. Now, a lot of litigation initially was there on TransFund only because a lot of server problem initially with connectivity and all that were there, and connectivity is the issue in many states. If you talk about J&K, when this 370 hearing is going on, 370 was there. It was abrogated, so entire internet was shut down. It happens at many places. So those things have to be taken care of. Now technology is there. I was seeing the website of the income tax department. Probably now they have added it, that if you want to see the act of a particular year, you can find out. But there are a lot of circulars also. They have some details of that also which have been overridden and all that. But if you see the website of ITAT, you don't find how much cases are pending in a way on different issues in the country. Or the orders passed by the tribunal are not searchable, free text search as we have in different portals. So unless we know, we will not be guided. And the department also has to be, I think, proactive in that to provide complete information to the professionals so that they can make use of it. There are issues decided by one tribunal, the professional may not be knowing, these issues are again being argued at the different tribunals. So that wastage of time can be saved. Similarly is the position I think with CBIDT also, CBIC also, and I can share about, my experience about the courts because I had been in 4 courts. A lot of issue regarding assistance by the department, and that also is a big problem I think. So there I think something has to be done, and which you also feel sometimes the law laid down, some judgments are not correct because you analyze them differently when the judgment is delivered. And there can be issue that the court did not get assistance on that. There may be judges who had been dealing with the tax matters because all of them may not have. And in that process, the difficulty arises because domain knowledge as such may not be there of the intricacies. Whatever provisions are cited, on that basis the judgment is given. And I have seen one judgment, there may be many. In the judgment, the case related to a particular year, but the provisions quoted in the judgment was of a latest year when the judgment was given. But somebody may not have noticed that, but that creates a problem then. Anybody can argue that this was the provision considered, though the provision considered may be of the relevant year. So these problems arise if the assistance is not there. You all are doing your job, discharging your duty, I think, for collection of taxes. Along with that, I think the coupled duty is to ensure that the money is not wasted. It doesn't go in corruption. I think you should have some research team or something. Now we have RTI. You can get a lot of information. In the media also it comes that where the money is being wasted, where the freebies are being given just to buy the votes and all that. So a lot of issues are there. It's not the platform to discuss that, but these should be taken care of because once we are contributing in collection of taxes, which is the major source of revenue for the government, we should ensure that also so that they also remain alert that if we are collecting money, we are taking the help of the professionals. We should also be careful in spending that money. It's public money basically. Now as in GST we say, use 2 terms, input and output. Basically with my coming here, I think I have taken some inputs from here and this output may come in some judgment only, whatever experience I got it here, whatever I learnt from here. And it's a program of a day. but sessions, the subjects are well thought of to cater to the different types of professionals who are in this conference, and everybody I think will go enriched with this. With these words, I am thankful to the organizers for giving me opportunity to be here, and all the best to the conference and all the delegates. Thank you. Jai Hind.
Thank you, my lord, for your encouraging words. And yes, sir, Calcutta is home for whomsoever comes here. We at DTPA are honored to have you here. Your lordship has correctly pointed out that with the changing times, one has to learn, unlearn, and relearn. Every year, DTPA releases a souvenir on the occasion of the annual conference. The souvenir contains articles on various topics: income tax, GST, insolvency, technology, etc. I would now request our chief guest to kindly release the souvenir. I would also request CA Girdhar Delia, Chairman Souvenir Cup Committee, and Co-Chairman Mr. Sujit Sultania to join the dignitaries on the dais. For the last 2 years, DTPA is releasing a publication, Selected Income Tax Issues and Insight, under the chairmanship of CAPR Kothari. This year, we will be releasing volume 3 of the said publication. Number of relevant issues are selected and analyzed by the various authors and compiled in this publication. I request our chief guest to kindly release the publication and request CAPR Kothari, Chairman Direct Tax Research and Publication Subcommittee, and Co-Chairman Ajit Tulsianji to join the dignitaries on the dais. Thank you, sir. I would now request our Secretary, CA Manjulata Shukla, to offer a vote of thanks.
Good morning, everyone. Honorable Mr. Justice Rajesh Bindalji, Distinguished Judge Supreme Court, fellow professionals, distinguished guests, ladies and gentlemen, it's honor and proud privilege to present a vote of thanks to Honorable Mr. Justice Rajesh Bindalji, Honorable Judge Supreme Court. My Lord, I am thankful to you for sparing your precious time out of your busy schedule and deliver the kind word of wisdom by which all of have been immensely benefited. Your Honor, we have noted your advices and suggestions for all the professionals. As you said, that we have to update and educate our professionals and the public at large for the changes happening in the income tax, GST and other laws. Sir, we do that. We keep continuously on a regular basis study circles, conferences and seminars. Rather, we do have a public interactions too for updating the public at large. We thank you once again for your valuable guidance. Sir, treating Calcutta as a home, we are humbled. We are so affectionate that if anybody is staying in Calcutta, they have to feel that Calcutta is a home to everybody. Thank you so much for being so humble to us. I also would like to thank dignitaries and the officers from the Revenue Department for gracing the occasion. Sir, we are so fortunate that the department has given a place to the DTPA in the Income Tax Department. This only shows their humbleness, and we are showing our gratitude towards them. Thank you, sirs, for allowing DTPA to be a part of the Income Tax Department. Thank you so much. Further, I would like to thank the delegates for their participation in the annual conference. I am humbled by the presence of large number of past presidents sitting in the first row and the second row, who are there to shower their love and blessings on us. Thank you so much for being here. I would like to thank all the members of the DTPA for attending this session. I would also like to thank our press and media friends who is there to cover our annual conference, and to all those who helped to make this annual conference 2022-23 a grand success. Thank you so much. Jai Hind.
We will be starting the first technical session immediately. We request everyone not to leave the hall and just stay inside. I request CA DS Agarwalji, President DTPA, to escort the chairman of the session, Senior Advocate Abhitosh Majumdar, to the dais. I request Sanjay Bajoria ji, Chairman Conference Committee, and CA Barkha Agarwalji, Vice President DTPA, to escort the speakers of the session, CA Jagdish Punjabi and Advocate Bharat Raichandani, to the dais. And Advocate Bharat Raichandani will deliver his address on recent jurisprudence in direct and indirect taxation. Chairman of the session, Senior Advocate Abhitosh Majumdar, who shall be giving his opening and closing remarks, shall also sum up the sessions. As an advocate in the year 1998 and was designated as Senior Advocate by Calcutta High Court in 2016. He practices specifically in the field of constitutional and revenue laws. He is the former Additional Advocate General of the State of West Bengal and is presently a member of the Legal Aid Services of Honorable Calcutta High Court. He has represented Commercial Tax Department, State of West Bengal, Excise Department, State of West Bengal, and many multinational corporate houses before various high courts and Honorable Supreme Court. I request Advocate Narayan Jain, past President DTPA, to come forward and present a shawl to Senior Advocate Abhitosh Majumdar. I request CA Sahib Singh Chaudhary, Executive Committee member, to present a memento to Senior Advocate Abhitosh Majumdar. CA Jagdish Punjabi is a practicing chartered accountant, practicing mainly in the area of direct taxation since 1989. He has been a lecturer in accountancy and taxation for a period of 17 years and is a regular speaker at various seminars, and has also presented papers and authored many articles for different publications across the country. He has been a guest faculty at the training programs conducted by the National Academy of Direct Taxes, Nagpur, in the past, as well as, and is also invited as a guest faculty by the Direct Tax Regional Training Institute, Mumbai, on various topics. I request CA PR Kothari, past President DTPA, to present a shawl to CA Jagdish Punjabi. I request CA Sujit Sultania, Executive Committee member, to come forward and present a memento to him. Advocate Bharat Raichandani is the managing partner of UBR Legal, a law firm having offices at Delhi, Bombay, Ahmedabad. He is a gold medalist in law and has been awarded Young Achiever Under 40 Award by Legal Era Awards in 2018 and Top 100 Legal Falcon Award by Lex World Talk at Dubai in 2021. He has been certified as one of the top individual lawyer in taxation by the Forbes Legal Power List in 2021. He has over 20 years of experience in arguing cases before the Supreme Court and various high courts of the country. He is a profound speaker and has authored several articles on various topics. I request CA Sanjay Poddar, Executive Committee member, to present a shawl to Advocate Rai Chandani. I request Advocate Arvind Agarwal to please come forward and present a memento. I now hand over the proceedings to the chairman of the session, Senior Advocate Abhratosh Majumdar, for his opening remarks on our topic of the session, reopening of assessments with respect to unexplained money, expenditure and assets. Over to you, sir.
A very good morning to all the delegates and members of Direct Taxes Professionals Association. I congratulate DTPA for organizing this annual conference with such distinguished speakers on board. I am honored and humbled by this invite, truly deeply from the core of my heart. The presence of Honorable Justice Sri Rajesh Bindal ji has made this occasion so special and momentous. Namaskar, sir. We are grateful to Honorable Mr. Justice Bindal for ushering in the necessary reforms in the justice dispensation system of Calcutta High Court. Thank you, my lord. I am honored by this invite, as I said so. Now, in this session, may I just give a quick word. In this session, Shri Jagdish T. Punjabi, who needs no introduction, will give his rendition on reopening of assessments with respect to unexplained money, expenditure and assets. And thereafter, Shri Bharat Raichandani, a very distinguished counsel, will share his perspective on recent jurisprudence in direct and indirect taxation. Both the topics are well curated. The first one is a legal quagmire centered around the new reassessment regime with the insertion of 148A and the amendments made to section 147, 148, 149 et al. Though the new reassessment regime was introduced to reduce litigation and streamline the process of reassessment, however, our experience is not so pleasant. I am sorry to say this, but it is so. The taxpayers have witnessed a radical surge in tax disputes in the last couple of years. Interestingly, the subject matter of most of the reassessment proceedings appears to be now unexplained money, expenditure and assets. Since tax implication arising out of addition of on account of section 68 to 69D amounts to expropriation because of the reason of 115 BBE. A greater circumspection is required while invoking these provisions. The keywords in section 148 are, if required, information which suggests and fit case to issue notice. These three keywords will play a very important role in the coming days, and it is already playing an important role as of now. Now, in reassessment proceedings involving unexplained money, expenditure and assets, the primary onus, this is my personal opinion, has to be discharged by the assessing officer. In my humble opinion, in this category of cases, an independent inquiry as envisaged in section 148 capital S clause small clause A would be sine qua non. Now, coming to the second topic, which is apposite for understanding the philosophy of fiscal laws. As Honorable Mr. Justice Bindal said, that the law is fast evolving. Even our constitution is an organic instrument. And our tax laws, by their very nature, are always adapting itself to the current economic scenario. Through judicial interpretative process, tax laws are expounded. Since both direct and indirect tax laws are now compliance oriented, as again my Lord Mr. S. Bindal pointed out, I feel, this is again my personal feeling, philosophy of tax laws is now to some extent lost in the labyrinth of this faceless regime. We must remember that interpretation and implementation of tax laws must be guided by economic realities. We must have a seamless tax administration which will facilitate ease of doing business. I remember in the memorandum explaining Finance Bill 2021, the expression which was used for introducing the amendments to Section 147 series was to ensure ease of doing business and not to create obstacles. With these words, I say let the session begin.
I now request CA Jagdish Punjabi ji to deliver his address on the topic reopening of assessments with respect to unexplained money, expenditure and assets.
Good morning once again. Apologies. Fine. Now, thank you, Chairman, sir, for introducing the topic and also pointing out the key areas where litigation is likely or is ongoing. The litigation on new reassessment is really very, very intense. I'm told in Bombay, about 70 or 80% of the litigation which is coming up is only on account of reassessment provisions itself. I do not know the figures here, sir, but this is what I'm told is the position in Bombay. Now, considering the time available, what I have been told is that I'll straight dive deep into the issues which are arising with reference to the new scheme of reassessment. As we are aware, the new scheme has been introduced effective 1/4/21. It has undergone a sea change. We understand that reassessment procedures have to be robust, considering the fact that it's less than 1% of the returns which are scrutinized, considering the fact that we have limited scrutiny concept which is there. We are largely following self-assessment, and therefore it's necessary that the law dealing with reassessment should be robust to capture any income which escapes assessment. However, we need to be conscious of the decision of the Supreme Court. In the case of Parshuram Pottery, where Supreme Court said that there has to be finality to stale issues cannot be raked up. Okay. So now, what was the object? We were told in the explanatory memorandum that look here, we are getting information from various sources under 285 BA, and that is the basis. From that information, we are comparing your returns, and that's the trigger. That's where we are going to reassess or be going to recompute. Therefore, they say that because of this method of gathering information, we need a new system, and therefore we are reforming the system. However, what's the objective? The objective is, or the expectation is, new system will result in less litigation, quite contrary to what we see on the field. Provide ease of doing business to taxpayers, as there is reduction in time limit by which a notice for assessment or reassessment can be issued. Now, is there really a reduction, or are we saying that through this mechanism of reassessment, we have increased our scrutiny time limit from 9 months to 3 years? I mean, is it that? And we have increased our erstwhile limit to 10 years. On the field, we find things are different. To begin with, first let's come to 147, which is the section. What is the jurisdictional fact which is required? There has to be a income chargeable to tax which has escaped assessment. Unless you have income chargeable to tax which has escaped assessment, you do not get jurisdiction under 147 to frame an assessment or a reassessment. Now, earlier, erstwhile 147 had a concept of reason to believe. That concept of reason to believe is given a go-by. If we now look at 147, it says if any income chargeable to tax in the case of SSC has escaped assessment for any assessment year, then AO shall do it. Therefore, unless you have income chargeable to tax which has escaped assessment, you do not get jurisdiction under 147, and therefore, it is, according to me, a provision which is much stricter than the erstwhile provision. Because erstwhile provision, at least the officer had reason to believe. That reason to believe may turn out to be true, may not turn out to be true. But today, for you to assume jurisdiction under 147, you need to have income chargeable to tax which has escaped assessment. What is the point I'm coming to? I'm coming to the point that as we go along, there is explanation 3. There was erstwhile explanation 3. You have an explanation here also, which says that while you are doing reassessment, if any income comes to your notice in the course of proceedings of reassessment, then that income which has come to your notice subsequently in the course of proceedings, that can also be captured. Now, the point which I am trying to highlight is that if perchance it happens that on the point on which you reopened my case, there is no addition made, but you found other issues where addition needs to be sustained. Will you be able to sustain that addition, or will you say, no, this cannot happen now? Let's look at the position. Unamended section 147, you have it on the screen, okay. Unamended section 147 had the words and also. Those words are consciously absent now. Therefore, the absence of the words and also in 147 indicates that legislature now wants department to be more vigilant, reopen cases. They are sure that with the methodology which we have provided, the procedure which we have legislated in 148A, only those cases will come up for reassessment where income has escaped assessment, and that is why the words reason to believe have been omitted. That is why the words and also have been omitted. Therefore, you will now argue that if you could not tax that item for which you reopened the assessment, then you undertook jurisdiction in a wrong manner. Your jurisdiction itself was wrong, and therefore all the proceedings will fall. As we go along, when I come later to 149(1)(b), I'll point out 3 Supreme Court decisions explaining what is the jurisdictional fact. For the time being, let's accept that for 147, the jurisdictional fact is income escaping assessment. The second point which I want to draw attention is that if you look at 147, both the present one and the unamended one, it says, and I read out, if the income chargeable to tax has escaped assessment for any assessment year, etc., the AO may, subject to provisions of 148 to 153, assess or reassess such income, or recompute the loss or depreciation allowance or any other allowance or deduction. Therefore, my point is that if during the course of reassessment proceedings there is another issue which comes up, should that issue be confined only to income, or can it also be confined to recomputing the loss or depreciation allowance or other allowance or deduction? If income escaping assessment already included these, there was no reason for 147 to mention them separately, that you shall assess such income or also or recompute the loss, depreciation allowance, deduction, etc. The fact that you have mentioned them separately and the fact that these are absent in the explanation, to my mind indicates, or at least is an arguable proposition, that these items can, if they come across, if you come across these items in the course of reassessment proceedings, it is a possible view that these items cannot be captured in the reassessment proceedings. I may point out that Bombay High Court in Jet Airways has held
by Mr. Punjabi is very opposite. It's extremely opposite because, as I was pointing out, that the requirement of requirement that you have to find, the assessing officer has to come to a conclusion that it is a fit case for reassessment, it gets intertwined with the concept of 147 right now. So it is always now, it is more than reason to believe. The assessing officer has to come to a conclusion at the stage of 148 AD that it is a fit case for assessment, reassessment, and not merely a reassessment on the basis of suggestion or any information which would suggest that income has escaped assessment as pointed out or as provided for in section 148 capital S clause small clause A. So we have to assimilate the laws. If we assimilate the laws, we will find a broad and correlation between the two provisions, one in 148A(d), another in 147. Because 148A(d), this entire provision was perhaps, the legislature of the Union Parliament was perhaps influenced by the judgment rendered by the Supreme Court in GK and Drive Shaft. It is basically a legislative recognition of a judicially evolved concept. A judicially evolved concept that yes, if somebody has to register any preliminary objections, you are done. Preliminary objections, then you register those objections, and first the assessing officer has to decide whether he has the jurisdiction to proceed with reassessment or not. And that particular judicial pronouncement is now imbibed in the statute itself. Now I hand over to Mr. Punjabi. Sorry for the interview.
Okay. We were on the Bombay High Court in Jet Airways, where Bombay High Court has said that if you do not make an addition on the ground for which you reopen the assessment, then on other issues you cannot make additions. Whether, the question is whether in the new regime this decision will hold good or will not hold good. To my mind, this decision will hold good with greater force, because if you do not make addition under, for the reason for which you reopen the assessment, it implies, it is suggestive of the fact that you have wrongly acquired jurisdiction which was not vested in you has been acquired by you, and therefore all the proceedings should fall. Now, we are told that the AO will make, any other income which comes to his notice. So now, can he make fishing inquiries and find out income which, other issues? To my mind, the answer is no. It is only that income or another issue which is incidental to the issue for which reassessment has been made, the proceedings have commenced, and while he is examining that issue, if something else comes to his notice, then certainly he is required to add, but he cannot make fishing inquiries and find out other issues as well. And this view, to a great extent, is supported even by SOP issued by the department itself, where they say the questioner shall seek specific and focused information. So your questioner has to seek specific and focused information on the points of inquiry as provided in the specific grounds that led to reopening of assessment. Therefore indicating that while those specific grounds are being examined, if anything else also comes to my notice, I will reassess that also, subject to the caveat which I pointed out, whether you can recompute the loss, depreciation, etc., because that has been stated separately. Now, earlier, we had an explanation to section 147, which defined what is the meaning of income escaping assessment. That explanation is absent now. Absence of that explanation raises questions as to whether income escaping assessment, does it presuppose that there should have been an assessment in the first place? And therefore, I'm asking a question that in cases where there was an intimation earlier, we are told that intimation is certainly not an assessment. Supreme Court in Rajesh Javeri has said that intimation is not the same thing as assessment. Therefore, can I argue that no, you are doing reassessment. Reassessment means there ought to have been an assessment first, is one question. Second question, what happens in cases where I have not filed a return of income? I have not filed a return of income. You ask me to file a return of income now. Can those be covered? Possibly, yes, because we have decisions to the effect that income escaping assessment is a wide term. Even where income is under-assessed or not assessed, both the situations will be covered. However, in the erstwhile regime, in the explanation, you also had cases where income is charged at a lower rate, where excessive relief has been granted, where transfer pricing report is not filed. Now, those three cases, to my mind, may not be covered under the new regime. So, if earlier in your assessment something was assessed as capital gains, and now a view needs to be taken that this is not capital gain, it is business income, and therefore chargeable to tax at normal rate and not at your concessional rate in 112 or 112A, that to my mind cannot happen now because of the absence of the explanation. Income escaping assessment may not necessarily mean income taxed at a lower rate. That could be something different possibly. I mean, we request Chairman Sir to express his view on this point later on. And in respect of an international transaction, earlier if I failed to furnish a report, it was deemed to be income escaping assessment. That to my mind will not amount to income escaping assessment just because I have failed to furnish a report of international transactions. Okay. Earlier, 147 had a third proviso, which said that the AO may assess or reassess such income other than income involving matters which are subject matter of any appeal, reference or revision. Now, this provision is absent. This provision is absent. Therefore, a doubt arises, will you say that even if the income was subject matter of appeal, reference or revision, that is again subject to proceedings under section 147, because department will argue that earlier we had a specific third proviso, that third proviso is now absent. To my mind, what are the decisions on this point? You have Allahabad High Court in JK Synthetics and Bombay High Court in Tejaji Saram saying that a reassessment is barred in respect of an assessment order which has merged into an appellate order. Well, when you file an appeal, the assessment order merges and it becomes an order of an appellate authority. Now, can you revisit something which has, which is not existing and which has already merged into a order of an appellate authority? However, you had Supreme Court in Madurai Mills as also in Amritlal Bogiral telling you that rectification is possible even after an appellate order qua items which are not dealt with in appeal. So you had these two decisions and you had two Supreme Court decisions. So therefore the question arises, does the order of AO merge into the order of CIT appeal or the tribunal completely, or is it only qua the items which have been dealt with? You have a direct decision of the Allahabad High Court in Allahabad Agricultural Institute telling you that in statutes like income tax law, legislature has not thought it fit to apply the general doctrine of merger. but doctrine of partial merger has been adopted, says the Allahabad High Court. Therefore, qua the items which have been decided by the appellate authority, to my mind, reassessment again cannot happen, but qua the rest of them, yes, you cannot say that just because I had preferred an appeal, the entire order has merged into it, and therefore now you cannot reassess. So this was qua 147. Let's come to 148 very quickly. Now, requirements of your 147 is subject to 148 and 148A. Therefore, requirements of 148 are to be mandatorily followed. Non-following of the requirements of 148 will render, the jurisdiction infructuous, the entire proceeding will collapse. 148 on its own is subject to 148A. Therefore, 148A also needs to be complied with. The notice has to be issued. You cannot have reassessment proceedings without a notice under 148. The notice must leave the hands of the AO before the last date mentioned in 149(1). The AO has to lose control over the notice before the date mentioned, before it gets time barred. Notice cannot be issued in the name of a dead person or a non-existing entity. Notice should be at the correct address or email ID. Service on portal without a real-time alert is not a valid service. Notice must be signed. That digital signature must state the name and designation of the officer. 282A. High Court has quashed on that ground also. I do not know how many decisions I'll be able to cover, but considering the paucity of time, but there are enough decisions on these propositions. Issuance of notice under 143(2) is mandatory. Now, notice under 148 can be issued if following conditions are satisfied. Number one, there is information with the AO which suggests that income chargeable to tax has escaped assessment. So, सबसे पहले तो ये precondition है. Now, this expression, information with the AO which suggests that income chargeable to tax has escaped assessment, has been defined in explanation 1 to 148. This definition is for both 148 as well as for 148 capital A. Whereas the second explanation is only for the purpose of 148. The second explanation to 148 is cases where AO shall be deemed to have information which suggests that income chargeable to tax has escaped assessment. Mind you, that deeming fiction in explanation 2 is only for the purpose of 148, but not for 148 capital A. This will have implications in survey cases, to which I'll come to it separately. But for the time being, just remember that explanation 2 only for 148, not for 148A, but explanation 1 applies to both the sections. Okay. Requirements of 148A, wherever applicable, should be complied with. Because there are certain situations where 148A compliance is not mandatory. So, that cannot be a precondition in all cases. Wherever applicable, 148 capital A should be complied with. Prior approval of the specified authority must be obtained before passing an order under 148AD and before even doing an inquiry under 148AA. Okay. Now, the question which I am now raising is, in the erstwhile regime, we had cases on what constitutes information and what does not constitute information. Is that controversy relevant today? Will those decisions apply today or not? That's the question I am raising. Or is it that because of explanation 1, now I don't need to understand what is the meaning of information? Because the entire expression, information with the AO, which suggests that income chargeable to tax has escaped assessment, is defined. Okay. Now let me test it. Let me take clause 1. Clause 1 of explanation makes a mention of any information in the case of assessee for the relevant assessment year in accordance with risk management strategy formulated by the board from time to time. ये first item है आपके explanation 1 में definition का. Understand this sentence, break it up. To come within clause 1, how many things do I need? First, any information. Second, in the case of SSC. Third, for the relevant assessment year. And fourth, in accordance with risk management strategy. Therefore, the first condition itself is any information. What is information? Not there in the new law. Not there in the old law either. But you have judicial precedents explain you what constitutes information and what does not constitute. So something may be there on my inside portal. Something may be claimed to be in accordance with the risk management strategy. But if that something which you have is not information, then your 148A clause 1 itself will not stand. Well, first it has to be information, and then the other three conditions need to be satisfied. Now, this clause 1 or the first item says, in accordance with risk management strategy formulated by the board, which means कहीं ना कहीं वो formulated होके पड़ा हुआ है. वो क्या है risk management strategy? There is nothing in public domain. We do not know what constitutes risk management strategy and what does not constitute. Bombay High Court has issued a notice asking the department to give its submission on number 1, scope of risk management strategy as specified in explanation 1. So Bombay High Court has told the department, now you come and answer this. What constitutes information for the purpose of 147? Second point which Bombay High Court has asked. And whether it is only restricted to items mentioned in explanation 1 to 148. Scope of information, whether restricted to information already available with you or includes information derived from an external source. Something which he had in his file, he had overlooked it. Can he wake up today and say, look, hey, here I have information. Oh, can I tell him, no, this was always there on your record. So what information is it? Information should be something new, something coming to you from an external source. And last, whether change of opinion is now permissible for initiating reassessment proceedings. These are the 4 items on which department has been asked to give its submission. Once those submissions come, indirectly we'll come to know what is the view of the department and how is Bombay High Court looking at that. Okay. Now another point. According to me, this meaning of the word information is going to be relevant because out of 5 items, in 4 items the word information is there. There are 5 items in that explanation 1. And please be mindful of the fact that as on 1421, there were only 2 items there. One was the first item, but it was with the word flagged. So not only information should be there, but it should be flagged information. And second was a final audit objection. Come Finance Act 2022, with effect from 1/4/2022, these 2 items got amended and 3 items got added. So now totally you have got 5 items in explanation 1. May I also make a mention at this stage of a scheme known as E-Assessment of Income Escaping Assessment Scheme, notified on 29th of March 2022. This scheme requires in paragraph 3 clause B that the notice under 148 should be issued in a faceless manner. Therefore, I am asking myself a question, that is it that all the notices issued on or after 29th of March 2022 by jurisdictional assessing officers are bad in law and therefore need to be struck down? If the answer is yes, are we not repeating Ashish Agarwal here? Is it not going to happen that countrywide all the notices will get quashed? I would believe, though that may be a legal view, equally possible for the courts to take a view that we'll read the act and the scheme harmoniously. Because see, the information came to your JAO. The inquiry was done by JAO with approval of PCIT of the JAO. The show cause notice was issued to you by JAO. You gave your response to JAO. The JAO came to a conclusion whether it is a fit case or not. So, and he, for this purpose, he took approval of his PCIT also while passing an order under 148 AD. In up to 31st March 2022, you required a second approval for issuing a 148. Effective 1422, that second approval is not required. If you have an approval for 148 AD, then the 148 approval is not required. But for 3 days, the scheme was operational, and those 3 days, 148 issued also required an approval. If you take a view that FAO should have issued it, which PCID would have approved 148? Was it the PCID of the jurisdictional PCID, or was it the PCID of the faceless officer issuing you a notice? If it was, are we suggesting that the faceless officer would have been a mere rubber stamp, and since 148 AD fit case has been decided, he should go ahead and issue a notice and take the proceedings ahead? I am unable to form a view on this. But I would believe no court ultimately will strike it down, considering today's day and age and the way matters are being looked at. I made a mention that income escaping assessment is a precondition. For that proposition, you have Delhi High Court in Blackstone Capital Partners saying that if there is no income escaping assessment, question of reassessment cannot happen. Then you have notice cannot be issued without prior inquiry or on the basis of wrong information. Now, 148 capital A, small a, which deals with conducting the inquiry, has the words if required. I'm jumping to 148A. I have missed out 1 or 2 issues on 148. I'll come back to them. Now, what is the importance of if required? Does the phrase if required, inquiry if required, mean that inquiry is at the discretion of the officer? And therefore, if he says, I don't want to inquire, I will not inquire, meri marzi. Law mein if required likha hai. Again, you have some observations of the apex court in Ashish Agarwal, where they said, anyway, conducting of an inquiry is discretionary. I mean, that sentence is there, coming from the Supreme Court. Now, according to me, with all humbleness at my command, I believe if required does not mean he has a discretion. If required means where the law requires that inquiry need not be conducted, inquiry should not be conducted. That is how you will interpret the word if required. If required would mean जहाँ law ने बोला है कि यहाँ inquiry की जरूरत नहीं है, वहाँ नहीं है, बाकी के cases में तो जरूरत है, and you will have to do it. And you have not one but several decisions of the high courts already telling you that inquiry is mandatory, including the decision from Calcutta High Court. So this was on if required. Now coming back to 148, the question is, our expression is information with the AO which suggests that income chargeable to tax has escaped assessment. Suggests को कितना importance देने का? Two views can arise. One, sir, the full expression is defined. तो एक एक word को मत देखो. पूरी expression का meaning आपको 5 clause में दिया है. So therefore, जहाँ भी वो expression है, you pick up the relevant clause and substitute. That could be one way how you look at dictionary meanings. The second could be no. उसमें भी we saw के information तो अपने को समझना पड़ेगा. Therefore, do I need to understand, suggest as an important ingredient? Because if I have got some information, but which is not suggesting that income has escaped assessment, I should discard that information. Or once I say, no, this is an information uploaded in accordance with the risk management strategy formulated by the board, जो भी है वो एक बार के लिए मान लेते हैं. Right? Therefore, now don't ask me further questions. The answer to my mind is no. And you have, a detailed discussion on this by the Madras High Court, if I'm not wrong, in a doctor's case. It's Dr. Matthew Cherian and others, where the Madras High Court says information must enable suggestion of escapement. So that information must suggest enablement of income, and I'm reading, it is only such information that suggests escapement of income and which, based upon the material in his possession, that officer decides as fit to trigger reassessment that would qualify. So this, and on the same line, you have Calcutta High Court in Excel Commodity and Derivative, where they say, as pointed out in the aforementioned decision, the term information in explanation 1 to 148 cannot be rightly resorted to, your jurisdictional high court, so as to reopen assessment, and this information cannot be a ground to give unbridled power to the revenue, says the Calcutta High Court. Sorry? Sir, I will share it later on, because now giving every citation, because there are at least 60 to 80 judgments or more than that, so I do not know. I will give you. For this particular, it is 328 CTR 710, Calcutta. Okay. In fact, case on hand, the information has been lightly used, says Calcutta High Court, which resulted in issuance of notice. As pointed out earlier, SSC had submitted explanation to the notice along with the documents. Okay. Unsigned notice, bad in law, says Delhi High Court in Sumanjit Agarwal. Unsigned approval, not a valid approval, and therefore notice issued with such unsigned approval or order passed with such unsigned approval, bad in law, Allahabad High Court in Vikas Gupta versus Union of India. Notice which is signed must be issued to me in a paper format or must be communicated to me electronically. In Jindal Exports and Imports, Delhi High Court said that if the AO has signed, but he has not mentioned his name and designation, such notice is also bad and need not be acted upon. Okay. You have Delhi High Court in GDR Finance and also in G4S solution telling you notice cannot be issued without prior inquiry. Therefore, prior inquiry is mandatory. Don't go by the words if required. If the AO says if required means inquiry ki zarurat nahi hai, that is not so. Okay. Now, what could be the example where inquiry is not required? Because I have to give some meaning to if required. No, because legislature cannot use any words without meaning. There cannot be any surplus word. So I have to give some meaning. Now, if you come to the explanation 1 to 148, one of the items is any information as a consequence of an order passed by the court or a tribunal. So if as a consequence of order of a court or tribunal I am required to do something, then for that I don't need an inquiry. So I would believe that is the reason where inquiry, I mean the words if required are there. Again, if required may not be. Okay, now coming back to survey case. Now explanation 2 says ke jahan pe survey hua na pe, so it will be deemed that the AO has information that income chargeable to tax has escaped assessment. Okay, information suggesting. So survey means, but that explanation as I mentioned then is only for the purpose of 148. It does not apply to 148A. Therefore, when I come to 148A, that 148A has proviso which says that in the following situations, 148A shall not apply. और एक्सप्लेनेशन 2 की 4 आइटम में से 3 आइटम रिपीट होती है, एक आइटम नहीं होती है वहां रिपीट. कौन सी आइटम नहीं होती है? सर्वे वाली आइटम रिपीट नहीं होती है. विच मीन सर्वे के केस में फॉर द पर्पस ऑफ 148 इट इज डीम्ड दैट देयर इज information suggesting that income chargeable has escaped assessment. But when you come to 148A, you have to comply. Now, when you go to comply with 148A, what happens is you have to do an inquiry. Now, that inquiry has to be with reference to information suggesting that income chargeable to tax has escaped assessment, which means, in my opinion, and I could be wrong here, would require right, that in a survey case, the AO will have to upload the findings of the survey on the inside portal. The uploaded findings will have to be in accordance with the risk management strategy formulated by the board, and then for the purpose of 148A, it will become. And then you will have to go through the process of 148 capital A. Okay, fine. Now, is 148A inquiry discretionary? We've already dealt with it. Okay. Now, the AO must not only do an inquiry, he must give me the material which he has in his possession, on the basis of which he initiates the proceedings. He must give me the results of the inquiry as well. He must not only give me what material he has, he must even give me the results of the inquiry. Failure to provide all this is violative of the procedure prescribed, and Bombay High Court in Anurag Gupta has struck down or has quashed down. Okay. Now, question arises, सब आपको एक नोटिस दे दिया 148A(b) के अंदर, आपने उसको चैलेंज किया, he felt कि he misfired. Can he issue you a supplementary notice? Can he go ahead and rectify the original notice issued to you under 148A(b)? This question has arisen in several cases, and the courts are saying no. A categorical no is the answer of Delhi High Court in Catchy Property Builders Private Limited versus CP. Okay. Now here, Delhi High Court said, no. Here what happened was, he issued 148A(b) on the ground that capital gain has escaped assessment. The SSC demonstrated that capital gain has been offered to tax. So what has escaped assessment? Your inquiry, what have you done? But he says, no. You have failed to prove. You have failed to prove the source of funds with which you purchased the shares. So he took a U-turn. From capital gains, he reaches sources of funds. The SSC argued that was never the issue. Your issue was capital gain. Department argued, give us permission to issue him a supplementary notice. Specific leave was granted. The court said nothing doing. They pointed out that in the earlier case you have given. The department pointed out to Delhi High Court that in the earlier case you have done. The Delhi High Court goes ahead and distinguishes. They say कि उस केस में क्या हुआ था, उस केस में एओ ने बोला था कि आपका 28 पार्टी का लोन बोगस है, ये अमाउंट है लोन का. 28 पार्टी का नाम नहीं दिया था. You came ahead and you said कि मेरे को नाम नहीं दिया, मैं कैसे डिफेंड करूं अपने आप को. तो the court directed, okay, ठीक है, उसको नाम दे दो. But that jurisdictional fact was there. The foundation was still there. But in your case, your issue is capital gain, and now you are asking him to prove the source of, funds with which you have purchased, right? So that's as far as. Now, legal question, for which we have Chairman Sir and Bharat also here. Does a writ lie against a 148AD order? Or now the thinking has started that no, 148AD order is an interlocutory order, and therefore your rights and liabilities are not affected by 148AD order. Wait, what has happened? Heavens have not fallen. No demand has been created on you. Therefore, wait, writ does not lie. Now, what is an interlocutory order? Interlocutory order is nothing but an order which is not a final order, order which is passed while the proceedings are going on, an order which does not determine the rights and liabilities of the parties. So how do I answer this question? The answer to this question is that we do have a decision of Supreme Court which says that even against an interlocutory order, a writ lies. It says, the decision is in the case of Surya Devi Rani Rai versus Ramchandra Rai, where Supreme Court says interlocutory orders passed by the courts subordinate to High Court, AO is subordinate, against which remedy of revision has been excluded by CPC Amendment Act, are nevertheless open to challenge and continue to be subject to writ of certiorari and supervisory jurisdiction of the High Court. So firstly, according to me, in my humble opinion, it is not an interlocutory order, because once you pass a 148AD order, your notice under 148 is a logical fallout, and I will have to undergo reassessment proceedings. That is affecting my rights and liabilities. That is where I started with Parshuram Potteries. So you are unsettling a settled legal position because of this 148AD order. Okay. Therefore, what it is not an interlocutory order, my submission, assuming I am wrong there, relying on Surya Devi Rai, Supreme Court, I will say the writ still lies. Okay. Now, 148A requires that I should be given a time period of minimum 7 days and maximum 30 days, which can be extended on an application made by me. Now, if the AO gives me a time of less than 7 days, what happens? The proceedings fall. The proceedings fall. Which, do I have any authority? The answer is ample number of authorities, 1 or 2 of them, Jindal Forgings in Jharkhand High Court, Bombay High Court in Agricultural Produce Market. Okay, now if the order in 148 AD is passed without considering my response and without rebutting my response, then also the proceedings are going to fall. Okay. Now, non-consideration fine, alternate remedy. Okay, can the AO in 148 AD travel beyond 148 AB? Understood what I'm saying? Can the AO in an order under 148 AD travel beyond the scope of show cause notice issued under 148 AB? The answer is a clear no. I don't think you need any authorities. Okay, but an interesting question arose before the Calcutta High Court in Excel commodity. They said, okay, he has traveled. तो क्या करने का? The department said, remand, why are you quashing? Remand, let it go back. The Calcutta High Court, where is the question? Why should I remand it back? He has exceeded his show cause notice under 148 AB, therefore I will not remand, says the Calcutta High Court in Excel commodity and derivative. Okay. The order under 148 AD has to be passed not on suspicion but on the basis of material on record. Okay. Now, I'll leave the court decisions and come to 1 or 2 other issues. Okay. Now, the question is that against an incorrect 148 AD order, I could have gone in a writ. Rightly or wrongly, I choose not to file a writ. I file a return in response to 148 issued to me. The AO will go ahead because he has passed 148 AD order. Now, my question is, in an appeal against an assessment made under 147, can I take up a ground that the 148 AD itself was erroneous and ought not to have been passed? Or the answer is no. You conceded to it. The answer is a categorical yes. You can challenge the 148 AD. You can challenge 148 AD in the course of appeal against an order passed under 147. Because if your 148 AD was erroneous, your 148 was erroneous and the foundation itself goes. Do I have authority? Yes, you have several principles coming out from the Supreme Court decisions. Number 1, the settled position is that if the initial action is not in consonance with law, all subsequent consequential proceedings will fall. And this principle is derived from a legal maxim, sub lato fundamento cadit opus, which means that if the foundation is removed, the structure falls. 148 AD is your foundation, the entire structure will fall. This is what Apex Court said in State of Punjab versus Davinder Pal. All the paragraphs I am reading are quoted there. Supreme Court there says, in Badrinath versus State of Tamil Nadu, Supreme Court has observed that once the basis of a proceeding is gone, all consequential actions, acts, orders will fall to ground automatically, and this principle is applicable to judicial, quasi-judicial and administrative proceedings equally. Similarly, in Mangal Prasad Tamoji, the Apex Court held that if an order at the initial stage is bad in law, then all further proceedings consequent thereto will be non-est and have to be necessarily set aside. And lastly, once again, in Albert Morris the apex court held that a right in law exists only and only when it has a lawful origin. Now, if your 148 AD was not a lawful origin, the entire thing is going to fall. Therefore, fine. Now, a question arises that erstwhile regime, we used to say, ये तो change of opinion है. Change of opinion पे reassessment नहीं हो सकता. Is that argument available to me today also? Or is that argument not available to me? Is change of opinion theory given a go by the new regime, or that is still available to me to argue? The answer is clear that the change of opinion theory is still available to me to argue. For this you have, Delhi High Court in Seema Gupta's case telling you that the issue which was discussed, deliberated, then cannot again be taken up in reassessment proceedings. Apart from the Delhi High Court in Seema Gupta, you have Karnataka High Court in Azim Premji Trustee Company, Delhi High Court once again in Kamlesh Vaswani, Calcutta High Court in Champa Impex, and there is some Madras High Court as well. Next question arises, are decisions rendered under the old regime valid under the new regime? Or will I say, no, no, पूरा law change हो गया, अभी पुराना statute मत दिखाओ मुझे, पुराना decisions मत दिखाओ, those were on the basis of the law as it then stood. So don't tell me to rely on those decisions. Is that correct proposition, or is that do I say that no, I will still continue to be guided by the decisions under the erstwhile law? Specific question came up before in fact, Calcutta High Court Division Bench in appeal examined this suo motu. This was not even a question there. There, the single judge dismissed the writ petition filed by the petitioner against a 148 AD order. Against that single judge's order, the assessee or the petitioner came up in appeal in Champa Impex Private Limited versus Union of India, Calcutta High Court. There, the appeal court sent everything back on the ground that the arguments which you are now taking, you never took it before the assessing officer. Therefore, we are sending it back. But the division bench said that the AO has said that he is not going to abide, or he does not accept the decisions relied upon by the assessee, because those were the decisions rendered in the old law. Now, this was not even an argument taken by the petitioner, but the court observes this, and they say that the law laid down by various decisions of the Supreme Court as to when and how an assessment can be reopened continue to hold the field irrespective of the fact that the section has undergone as amendment. So as to how and when reopening has to happen, they say old law will apply. That's what the Calcutta High Court says. Okay. Now a question arises that an approval is required for passing a 148 AD order, that it is a case fit for issuance of 148 notice. If my AO is of the opinion that no, this is not a fit case, still he needs an approval. When he sends the papers for approval, when the AO sends the papers for approval to the specified authority, the specified authority says, no, no, how are you taking this view? This is a fit case for approval. Based on that suggestion of the specified authority, AO changes his view and he passes an order under 148 AD. Is such an order valid, or is such an order invalid? Very recently, on 14th of July 2022, Supreme Court in Amarendra Kumar Pandey versus Union of India has in para 28 said that wherever an act or the statutory rules left an action dependent upon the opinion of authority, which is in our case the AO, by some expression such as is satisfied, is of the opinion, is of the reason to believe. So whenever law uses these words and gives an authority to a particular, designation, then the opinion of that authority is conclusive. The specified authority cannot change the opinion of the AO. And Supreme Court says that while coming to the conclusion that it is fit case or not, whether his opinion, how should he take, there should be 4 things which should be seen. Number 1, the procedure prescribed by the act or the rules for formation of opinion was followed. Number 2, the authority acted bona fide. He did not act mala fide. Number 3, the authority itself formed the opinion and did not borrow opinion of somebody else. All these 4 conditions need to be cumulatively satisfied. Now this third condition is not being satisfied, where at the instance of specified authority I am changing the view. And 4th, if the authority did not proceed on a fundamental misconception of law and the matter in regard to which the opinion is formed. So facts and law should be properly considered. Borrowed satisfaction, not good satisfaction, here away. I come to the major issue, 149(1). 149(1) small b, which gives an extended power to the AO to reopen assessment for a period beyond 3 years and up to 10 years. There are additional conditions attached. 149(1)(b) gives you this extended time period if the AO has in his possession one of the 3 things: books of account or other documents or evidence. So information suggesting escapement अपनी जगह पे, उसके अलावा अगर ये आप beyond 3 years आ गए and up to 10 years, तो he must have in his possession books of account or other documents or evidence. Such material in possession of the AO should reveal what? Reveal that income chargeable to tax which has escaped assessment amounts to or is likely to amount to 50 lakh or more. And such income chargeable to tax is represented in the form of 3 things. For the first year 21-22 it was only asset, but thereafter 1422 2 more added. First one, an asset. Asset is defined. I'll come to I have issues there also. Second, expenditure in respect of a transaction or in relation to an event or occasion. 3 things, huh? Expenditure in respect of a transaction. Expenditure in respect of a transaction or in relation to an event or occasion. Third, an entry or entries in the books of account. Now, first is an asset, singular. Second, expenditure in respect of a transaction or in relation to an event or occasion, again singular. Now you may tell me singular includes plural, so what? I mean, why are you wasting time on this? The C is what makes me think, or the third, an entry or entries in the books of account. अगर singular includes plural, तो यहाँ आके entry और entries क्यों लिखना था आपको? The fact that यहाँ आके आप singular और plural दोनों बता रहे हो मेरे को is suggestive of the fact कि जहाँ आपने singular use किया आपको singular चाहिए, जहाँ आपको plural चाहिए आपने plural बता दिया मेरे को. Okay, now books of account defined term, other documents. Now first question, किसका books of account? किसका books of account? किसका डॉक्यूमेंट, किसका एविडेंस? मेरा. कहां से आएगा एओ के पास? Please be mindful of the fact that AO must have in his possession books of account or other document or evidence. How does he get this? If it is mine, see, it can be either mine or it can be किसी और का. If it is mine, it can reach the AO in 3 situations I can think of. Number 1, search हुआ, वो books लेके गया, so he has in his possession. Second, survey happened, he took. Third, he issued a notice, he issued a summon, he called for the books and he impounded them. He says, मैं तो रख लेता हूँ इसको, मेरे को चाहिए, right? Therefore, these are the 3 ways in which my books of accounts can reach the AO. Simultaneously, there could be a search on somebody else. His books of account may be there with the AO, right? How do they reach my AO? Because in a search, if there is material found which pertains to me, then the AO of the search person has to transfer that material to the AO of the person to whom that material pertains. Therefore, the AO of the search person would have sent that to my AO. So, books of account तो समझ में आता है मेरे को. What is other documents? Loose slip mila, is that other document? How will you understand other documents? Madras High Court in P.K. Chettiar's case, 8 STC 741, said other documents used. The authorities can require production of accounts and other documents. That was the language there in Sales Tax Law. Books of account and other documents. They said other documents in this section is vague and indefinite under the rules of construction of statute, where general words follow particular words. The general words will take color or will be construed in the light of particular words. This is what is known as ejusdem generis rule. Therefore, says the Madras High Court, other documents will be in the nature of account books, such as bill book, etc., that have some relation to accounts and not any correspondence, etc. So, koi letter mil gaya, so you can rely on this and possibly take an argument. Evidence, again, I mean, evidence means something equivalent to proof, something equivalent to material on the basis of which court can come to a conclusion about existence or non-existence of a disputed fact. Now, what should happen? These books of account, other document or evidence must reveal. Reveal means what? Show nahi bolta hai wo. Must reveal. Reveal is, what is reveal? Something which was earlier not known. Something which transpired now because I got this. Ab tak to mujhe malum hi nahi tha ye. For the first time I got to know, because I got this, this is the revelation of these books of account documents. Now, according to me, this provision is exactly the same as 4th proviso to 153A, which gave jurisdiction to the AO in a search case to reopen between 6th to 10th year. वहां पे भी same amount था, वहां पे भी सिर्फ asset था, यहां पे भी जब introduce हुआ तो amount भी same रखा, asset भी same रखा. Therefore, possible to take a view that, I am not saying conclusive, we cannot, because the language is not suggestive, it is conclusive, that this clause read with the intention that we want to reduce the time limit applies only to search cases. Because now your search cases are also governed by reassessment provisions. Again, this is search is the mechanism, search or survey is the mechanism through which you will come in possession of these things. Again, the question is, what is the meaning of represented by? Because what we are told is that the books, etc., must reveal that income chargeable to tax represented by 1 to 3 has escaped assessment. Therefore, according to me, represented by would mean presence of one is equivalent to presence of another. When you appear in the tribunal on behalf of your assessee, your presence is same as you represent the client. Your presence is the same as your client's presence. Your submission is the same as the submission of your client. Your acquiescence to something is same as acquiescence of your client. Therefore, presence of one is same as presence of another is the meaning of represented by. So, how do I read this? I read this in a manner that AO must have found some undisclosed asset, some undisclosed, some expenditure incurred by me or some entry. Now, if you run through these three clauses are nothing but your section 68 to 69C. Your asset would be covered by 69, 69A and 69B. Expenditure part is 69C and your entry or entries is nothing but 68. Therefore, I would feel that someday someone will have to come to a conclusion that if based on material this is revealed, then I will initiate 149(1)(b). And mind you, this is a jurisdictional fact. I did mention that I will deal with jurisdictional fact. How much time do I have, sir? Time is up? Okay. Okay, fine.
Maybe another 5 minutes.
Another 5 minutes. Okay. Supreme Court in Arun Kumar versus Union of India says, a jurisdictional fact is a fact which must exist before a court, tribunal or authority assumes jurisdiction over a particular matter. A jurisdictional fact is one on existence or non-existence of which depends the jurisdiction of a court, a tribunal or authority. It is the fact upon which administrative agency's power to act depends. If jurisdictional fact does not exist, court authority cannot act. Very recently, Guwahati Tribunal, in the case of Goldstone Cements Limited, very recent order, held that presence of material in possession and the fact that the asset is an undisclosed asset is sine qua non for assuming jurisdiction under 4th proviso to 153 capital A. The discussion there is excellent. The discussion there is excellent. They have discussed jurisdictional fact threadbare by quoting 3 Supreme Court decisions, etc. I think one needs to read that decision definitely and borrow the concept from there and apply it in the context of 149(1)(b). Okay. Now, the last interesting question. One of the items there is expenditure. Expenditure in relation to a transaction or event or occasion. Very recently, before the Delhi High Court, a case arose where a trust incurred some expenditure in excess of 50 lakh, and it was contended that this is not for the purpose of object of the trust. This fact came to light in the course of survey which was conducted on 7th of February 2022 after the Finance Act had kicked in. So survey happened after the amendment. The counsel for the SSC argued, you can't apply this law. Look at the date when I incurred the expenditure. That expenditure was incurred way back in 2016. What was the law then? Then the law did not permit you to reopen. Therefore, you are now not within your rights to reopen the case. Delhi High Court held that prima facie there is merit in the contention. Mr. Datar argued for the SSC, and Delhi High Court says there is merit in the contention. Notice has been issued. Matter is fixed up for November 2023. Now, asset definition, I said, is given in an explanation. It says asset shall include. Asset shall include. और वो बोलता है immovable property being land or building, shares, securities, loans and advances, deposit in bank. 4 items only. So does it mean कि jewelry मिला तो is not an asset? Does it mean tenancy right मिला तो is not an asset? Because in the context of 50C, we say tenancy right is not land or building, right? And I can go on and on with the examples. Now you may say, sir, this is an inclusive definition. Asset shall include, and therefore 4 items. Therefore, everything else is also an asset. But my contention is no. This is an exhaustive definition. The settled rule is that when the items which follow the word include are even otherwise covered by the normal meaning of the word defined, then such a definition, though it uses the word includes, has to be understood as an exhaustive definition. Now this is something where possibly legislature has misfired, right? Possibly, and you have not one, but you have a couple of decisions coming from Supreme Court telling you this proposition, which I just mentioned, that if what follows the word includes is even otherwise covered by the definition of the term defined, and undoubtedly land building loans and securities, bank accounts, all these are even otherwise assets. So there was no need for you to mention these 4 assets. In such a situation, they say that the definition has to be understood as an exhaustive definition. Okay, if you want, I'll give you the citations, but the names of the decisions at least. Yeah, the decisions are South Gujarat Roofing Tiles, AIR Supreme Court 1977. You have a Jairam Das Vishan Das, Leucoplast versus State of Goa, Bombay High Court in the context of excise law. And you have again Supreme Court in Commissioner of Customs versus Carrier Equipment, all 4 giving you the same proposition. Therefore, possible to argue. Now lastly, you have 149(1)(a), this limit of 50 lakh. Should it be qua 1 year or could it be over a period of years? Initially, for the year 21-22, there was no 149(1)(a). Therefore, the view was that एक asset एक बरस में 50 लाख का. तब 21-22 में खाली asset था उस 3 item की जगह. Then from 22, that 1 item became 3 items. 1 item became 3 items, and you also have 149(1)(a), which now tells you that if investment is made in an asset, before 149(1)(b), over a period of years, then each year in which investment is made shall be reopened. Therefore, if I have purchased a building, paid 20 lakh, 10 lakh, 10 lakh, 10 lakh, then those 4 years can be reopened because they say aggregate. My question, should I take only one asset of 50 lakh or can there be multiple assets? Now similar fiction is there in 149(1)(a) for expenditure. But when we were on clause 2, I mentioned 3 expenditures. Expenditure in relation to a transaction, expenditure incurred for a transaction in relation to an event or an occasion. In 149(1)(a), only 2 items are mentioned. Expenditure for a transaction is missing. Therefore, if it is expenditure for a transaction, then it has to be 50 lakh in 1 year. But if it is expenditure for an event or an occasion, then it has to be 50 lakh in an aggregate. Again, the controversy of whether one event or one occasion or multiple events aggregated will continue. Fine. That's, I stop here for want of time. There are several other issues, but we stop here. And on unexplained expenditure, I was told that bogus purchase is being added as unexplained expenditure. Now, according to me, that's grossly incorrect. For the simple reason that when you go to 69C, it says when you have incurred an expenditure, therefore you are admitting I have incurred, number 1. And number 2, the source is not known. A bogus purchase is there in my books. Therefore, the source is very much known. So you cannot definitely tell me that the bogus purchase addition can happen under 69C. I am not saying that the addition cannot happen. All that I am saying is it cannot happen under 69C. Thank you very much for a patient hearing.
Thank you, sir. I would now, the second topic for the session is recent jurisprudence in direct and indirect taxation. I request Advocate Bharat Rai Chandani to deliver his address now. Our chairman will sum up for both the sessions together after Mr. Bharat Rai Chandani speaks.
A very good afternoon, friends. Okay. Don't worry, I'll close in time. Okay, I will not come between you and your lunch. No, sir. We lawyers are used to this in the court, sir. Okay, so there is no difficulty about it. Sorry, sir. Concepts, yeah, we'll clear all concepts, sir. It will take 10 minutes. It will take 10 minutes to clear any concept, sir. Okay. Friends, the subject that I've been asked to speak on is recent jurisprudence in indirect tax and direct tax. Of course, Jagdish ji has explained a lot of principles, which all part of it I would also want to cover, but so for want of time, I don't know how much we can cover. I've tried to put this presentation can be shared with all of you. I've tried to put about 20 or 30 important IDT judgments and 20-30 important direct tax judgments. Okay. Before we go on to this, okay, the most important subject that I think today everybody is grappling with is, as sir just pointed out, bogus purchases. Okay. Bogus purchases, whether it is income tax or whether it is GST, everything is bogus. Okay. If you are to believe the revenue, everything is bogus. Okay. Nobody is there from the revenue, no? No, they can be. There is no difficulty. I am entitled to my opinion, my submission. This is my submission. Okay. I am not saying that there are no bogus transactions. I am not even for a moment, please, for the record, I am making a submission. I am not even for a moment suggesting that there are no bogus purchases. Okay. But to say that every purchase is bogus or every supply is a non-supply, okay, that there I would have a slight difference of opinion. Okay. Or as they call, what is called today is fake transactions, fake invoicing. What do you mean by fake invoicing, sir? What do you mean by fake invoicing, fake purchases, fake supplies? There is no real, it's all, what do you basically mean? There is no legal term as fake invoicing, sir. There is no term fake either in the income tax statute or in the direct or the GST statute. What they essentially mean is supply of goods and services without the underlying goods and services. That is, there are only invoices. Okay. There are only invoices where purchases are shown in the books as purchases and sales are shown as sales in the books. Okay. 2-3 important legal principles I want to point out. Okay, there is a judgment, there are 2 judgments of the Calcutta High Court also on this point. First point is, there are no goods and services and therefore these are non-genuine supplies. My first submission is, if there are no goods and services, then it's not a supply itself. Once it is not a supply, you are out of the act. You are out of the act. Nobody has till now argued. Of course, we are arguing in the High Court. Okay. Once you say that there are no goods or services, it is not a supply. Once it is not a supply, it is not a supply under Section 7. It is out of the act. It may be, as far as income tax is concerned, it may be different position. Okay. As far as GST is concerned, okay, according to me, this is not really a GST issue. It is not really a GST issue because when I purchase the goods and I sell the goods, I take credit, I debit it when I make sale. If there is no purchase, there is no sale. If I did not purchase the goods and services, I could not have supplied the goods and services. Therefore, if there are no purchases, there could not have been a sale. And therefore, to that extent, there is no revenue implication as such. There is no loss to the exchequer. And therefore, according to me, it's not a GST issue per se. That's 1. 2, if you see the condition in the law, Section 16(2) requires you, and it talks about receipt of goods and services. What do you mean by receipt of goods and services? According to me, 16(2) requires the receipt of goods and services should be legal receipt of the goods and services, not physical, not actual. There is no requirement for you to prove that the goods were transported from Bangalore to Calcutta. So long as the goods exist, again I am making a very important rider, so long as the goods exist, okay, you are eligible for taking credit. You don't need to prove the actual and physical movement of the goods. Unlike the erstwhile central excise regime where there was a requirement under Rule 3 which said that you should receive the goods in the factory, there is no such requirement under GST. What happens in a high sea sales transaction, sir? The goods are on the high seas and the goods are sold by A to B, B to C, C to D, D to E. And E is the person who actually files the bill of entry. Are these sales illegal? Answer is no. They are all legal sales. So long as the goods exist, so long as the goods are existing somewhere, or so long as the services are existing somewhere, these are all genuine transactions. I am not suggesting for a minute also where there are no goods and services, those may be genuine or no, because you have not satisfied the condition of the rule. If you have not satisfied the condition of the law, you will not be eligible for credit. 1. 2. Most of us question this. What is input tax credit? What is this input tax credit that I am eligible for? Is it your fundamental right? Is it a right guaranteed by the Constitution Part 3? Answer is no. According to me, please note, input tax credit is not your fundamental right. It is not a right under Part 3 of the Constitution. Input tax credit, revenue also argues many times it's a concession, it's a benefit. No, according to me that also is not correct. According to me the correct answer is input tax credit is a statutory right, is a right granted to you by the statute, and therefore the statute is well within its powers to impose such conditions and such restrictions as may be required for you to satisfy to claim that benefit. If you don't satisfy the conditions prescribed by the statute, you are not eligible for that benefit. Okay. Now, whether those conditions satisfy the test of Article 14 or no is a different question. Whether those conditions are violative of Article 14 or no is a different subject matter. Okay. Therefore, when you say, apart from the receipt of the goods and services, there is one more condition which says that your supplier should have paid tax to the government. Your supplier should have paid tax to the government, and then alone you are eligible for credit. Now, this is a condition which is subject matter of challenge before various courts, saying that whether such a condition can be imposed or not. What is your view, sir? Can such a condition be imposed? That you will be eligible for input tax credit only when your supplier has paid tax to the government? Are you eligible for credit otherwise? Is this condition valid? Is this condition valid, sir? No.
It can't be.
Why not, sir?
Because once the seller sells the goods and the buyer purchases the goods and whatever tax is paid on the invoice, the tax is paid by the buyer. Now, if the seller does not deposit the tax with the Union Exchequer or the State Exchequer, if the seller does not deposit the tax with the Union Exchequer or the State Exchequer, as the case may be, the buyer's claim for the ITC cannot be just revoked or just...
But that's a condition of the statute, sir.
That's a condition of the statute, no doubt. 16(2) is there.
Is it valid, sir? Is it valid? Is it valid, sir? No, sir. It's there as a condition in the statute. Is it valid? How many feel it is valid? How many say it is invalid? बाकी politician है क्या? According to me, as I told you, sir, okay, the statute has powers. The legislature has powers to impose conditions. Now, the only limited inquiry, according to me, the court can make is this condition capable of being performed?
Yes.
Have you imposed a condition upon me without giving me the wherewithal to comply with that condition? There, I agree with sir. According to me, answer is no.
No.
And therefore, the condition should fail. And therefore, the condition should be held to be ultra virus. I'll tell you why. Because we as a fair democracy, when we introduced the law for the first time in 2017, and in fact, this particular law has been on the writing board since 2004. For the first time, when the first white paper on GST was published, the fundamental concept, the underlying concept of GST was seamless credit, seamless input tax credit. Okay. Today you may say it seems very less credit. This was the fundamental principle. Okay. And when they introduced the GST law in 2017, there was a section called Section 42. There was a section called Section 43. There was a scheme of the forms. There was a scheme of the rules which enabled me, the recipient, to do matching, which enabled me to change the returns of the supplier, which enabled me to tell the supplier on the portal that there is an error committed by you, Mr. Supplier. You have not paid the tax. You have not filed your returns properly. This particular scheme was never put in operation. In absence of this, according to me, the condition fails. There is no wherewithal today for me to comply with this condition, and therefore it's an impossible condition for me to satisfy. This is not, please note, this is not a civil dispute between me and the supplier. It's not a civil dispute where the revenue can say you go after the supplier and get your credit back. And therefore, according to me, to this extent, the condition is bad. And therefore, the condition should be either read down or struck down, saying that unless you provide a mechanism for me in law to comply with this condition, the condition cannot be complied
Workable,
with.
not workable. Right.
Many times they say, your supplier registration is cancelled. Your supplier's registration is cancelled. Okay, these days registration, according to me, has been given such paramount importance, sir. They had a drive. They issued a circular to weed out what? Fake registration. Again, what do you mean by fake registration, sir? What do you mean by fake registration? So that place where you are registered, you don't stay there, no? That is fake registration. Is that fake registration? No, sir. According to me, no. There is no such thing as fake registration.
At all.
Except one. I'll tell you the answer for that also. What do you mean by fake registration? Today under the GST law, again, let us not be regressive. Let us not look at old laws under the old erstwhile central excise law, under the erstwhile VAT regime. Okay. We have progressed. We are now 6.5 years into GST. Today the concept of manufacturer does not exist. Today the concept of service provider, dealer does not exist. First stage dealer, second stage dealer, all these concepts have paled into insignificance. Today we don't have a concept of factory. We don't have a concept of depot. We don't have a concept of storage. We don't have any concept of premises. Please note, what is this registration? This registration is merely an address for communication. Today, with this day and age of technology, what do they do? They upload everything on the portal. Everything is on the portal, no sir? All your documents are uploaded on the portal, notices are on the portal. Why do you need address? Why do you need a place of business? Will you ever say that I will not demand tax from you because you are not registered? Will you ever say I will not demand tax from you because your premise is not registered but your premise is somewhere else? Answer is no. The registration is a procedural requirement as far as merely an address for communication. That's it. Period. This is my opinion again. People may have a different view. That's it. Today you have your email IDs, your phone, mobile numbers. You don't need physical place of business. Therefore, this drive they go that you are not in this premises, therefore you are fake. You are not fake. Your sales are not fake. Your services are not fake. According to me, only and only one situation of fake registration exists. That is impersonation. If I am using some fake Aadhaar card, I am not sobody, or I am using a fake PAN card, that is a case of impersonation. And that alone is a case of fake registration, no other. And even in that case, please, with great respect, GST has absolutely no role to play. Tax authorities have absolutely no role to play. How many FIRs are filed? In this fake registration drive that they said we have weeded out what 10,000, 20,000 registrations. How many FIRs were filed? This is a case where they should report to the local police saying that an offence under 419, 420 has been committed, please lodge an FIR. And that gentleman should be arrested. Not for violation of GST, not for payment of taxes, not for taking credit, but for 419, 420. Therefore, according to me, please note there is no such thing as fake registration. Yes, you may say that there are supplies of goods and services without actual supply. And therefore, condition of 16(2)(c) violates for qua the recipient. Qua the recipient. Okay. In this context, okay, everybody is being issued notices saying that you are not eligible for credit because your supplier's registration has been cancelled. Can credit be denied on this ground? According to me, answer is no. You may cancel his registration for any reason. For any reason. You may cancel it retrospectively also. But that cannot be a ground to disallow credit to me. That cannot be a ground to disallow credit to me. The first and foremost principle is, who is this supplier? Is he registered with you? He is registered with you? Who gave him registration? You? Okay. So therefore he is your illegitimate child. And now you disown him and say that I will not give you credit because you purchased from him. Because you purchased from him. And therefore what am I going to do? What action did I take against this supplier? Who? Otherwise in law, because there is a provision under 76, 78, 79 for recovery of the tax, any amount which has been collected as representing GST has to be paid to the government irrespective whether it's a supply or no. Did you invoke that provision against this person? Did you enable a mechanism for recovery from him and you failed? Then did you approach me saying that since I have failed there, now you cannot take this credit because I am unable to recover this tax? No. Not in one case. There may be exceptions, sir. Please, I do not know. At least the cases that we argue in the courts. There may be exceptions. But not in these cases, any attempt is made to recover this money from this supplier. In absence of such a recovery, according to me, credit cannot be denied to you. Question cannot be raised. Another important point, okay, is about the burden of proof. Okay. There is a judgment of the Supreme Court in Ecom Gill, which says under the erstwhile Karnataka VAT Act section 70 that the burden to prove is upon the purchasing dealer. Mere invoice is not good enough. Mere payment is not good enough. You have to prove the delivery of the goods and services, the receipt of the goods, the transportation documents, receipt, challan, etc., to prove. And the burden of proof lies on you. Will that judgment apply in the context of GST, though it is being applied by the tax officers? Because section 155 of GST Act also provides for burden of proof. Will that judgment apply? Please note, according to me, there is a legal distinction between a burden of proof. Sorry. According to me, there is a distinction between burden of proof and onus. Burden of proof, the initial burden of proof lies on the assessee, that is the purchaser. But the moment you produce a copy of your invoice, the moment you produce that I have made the payment through banking channels, etc. And please note, there is no allegation and there is no evidence to the contrary that this money has been routed to you in cash, etc. That's a different matter. That this money has been routed to you in cash. Then your burden is discharged. Then the onus shifts. And the onus shifts on the revenue to prove that there is no actual supply of goods and services. Okay. And what is the evidence with the revenue in these cases, sir? What is the evidence with the revenue in these cases? Not lorry receipt, not purchase receipt, etc. They will say that there is a statement of the supplying dealer that I have not supplied the goods. Is that conclusive? According to me, no. Please note, even those statements are recorded under section 70. They are not conclusive till they are put on oath. Unless and until any statement which is recorded under 70, it is put on oath, that is, it is put on cross-examination, it is not binding. Not binding on the maker, not binding qua you. And therefore, in any of these matters, please seek cross-examination of all the witnesses whose statements have been recorded. In absence of that, the revenue's onus is not discharged and therefore you will not be eligible, you cannot be denied credit. Okay. This is a recent Calcutta High Court judgment, okay, where the credit was sought to be denied on this ground only, that the supplier registration has been cancelled. The High Court said no, the High Court relied on Bharti Airtel's case. Okay. Bharti Airtel is one more important case, sir. Okay. Everybody was very critical about the Supreme Court, saying that how Supreme Court has passed this judgment, saying that 900 crores refund Bharti lost because of problems or errors with the system. Because of the problems and errors with the system. Please note, I for one, okay, though the Supreme Court judgment may be harsh in that sense or may not be equitable, I for one agree with the Supreme Court. Please note what the Supreme Court is trying to highlight there is. This is what I have been crying from 2017 itself and advising in each and every conference is this. Please let us not forget that man made computer. Computer did not make man. It is your tool. It is at your beck and call. It is at your assistance. It's, as the Supreme Court says, the procedure is a handmaid of justice. Let us not make it its mistress. This system, the portal, the online system, okay, if it doesn't work, then what happens? What will you do? Nothing. What were you doing? That's what the Supreme Court asked the question to Bharti. What were you doing prior to 2017? Why couldn't you do the same thing after 2017 also? Forget the system 2A, GSTR 2A, etc. What were you doing? Therefore, according to me, again, I request all of you is, wherever the system doesn't work, wherever the portal is not functioning, okay, wherever there are system errors, okay, please don't blame the system, please raise tickets, please put up a grievance. Please put up a grievance. If the grievance is not available online, file a physical grievance. Many people ask me, sir, these days no commissioner is available, no tax officer is accepting anything physically. They say, please speak to us through the portal. Once you don't speak to us through the portal, please don't talk to me. No difficulty, sir. You have either email IDs. Today's day and age, you can send it by courier, speed post, fax, etc. This is because your claim should be alive. Your right is at stake, not the tax officers, sir. Therefore, please keep your claim alive. Please keep your right alive. If you do not keep your claim alive, if you do not keep your right alive, this is what is going to happen, what happened to Bharti. Okay. There is a recent judgment of the Punjab High Court, of the Delhi High Court, as well as, okay. Another important point, sir. During the course of search and seizure, sir, during the course of search, these people come, they ask you to make some deposits. They ask you to make some deposit. They say, many times they give you threat of arrest, that unless you make this deposit, I will arrest you. Okay. And during the course of search, etc., you make the deposit of this money also. Is it legal? Is it legal? Answer is no. It is plainly illegal. There cannot be many deposit during the course of investigation unless, please note, there is a rider there also, unless it's a voluntary deposit. Unless it's a voluntary deposit, there cannot be any recovery during the course of investigation. If during the course of investigation the assessee voluntarily makes a payment, that deposit can be made. Now there is a serious question as to what is voluntary, what is involuntary. Okay. Because for the purpose of payment of tax, there is only one form, that DRC 03, which says that it's voluntary payment. So there is no form of involuntary payment. Then what do we do? Many people ask me this question, sir. During the course of search, during the course of seizure, they asked me to make some deposits. And I made the payment through DRC 03. Then in such a case, what do I do? Please note, even in the form DRC 03, there is a column for remarks. There you can add that this payment is made under protest. One simple line, this payment is under protest, there is no notice, there is no crystallization of liability, and therefore this payment is being made under protest. Forget that for a minute. So many a time tax officers may not allow you to do that. Then what do? You can write a separate letter of protest saying that you had come, I made this payment, though I do not agree with the liability, I have made this payment under protest. This is important to keep, again, very important to keep your claim alive. Because it is possible that they may not issue any show cause notice to you if you pay the tax and interest. And therefore you will not know whether this tax was rightly paid or not. Two, please note, as far as refunds are concerned, this money will not come back to you unless this protest is there. Second, suppose the tax officer does not issue any show cause notice to you, this money will never come back to you unless you lodge a claim for refund under 54. Now, as far as 54 is concerned, please note, there is a departure from erstwhile 11B and erstwhile 27 of the Customs Act, or rather today also Customs Act. There is no provision for payment under protest. Any and every refund claim has to be filed within 2 years. If you do not file the claim within 2 years, your money is gone. Therefore, these are important points that even if you make the payment, you lodge a protest. If a notice is issued to you, well and good. But if a notice is not issued to you within a period of 2 years from the date of protest, please file a claim for refund. That will keep your claim alive, otherwise you can say goodbye to that money. This money paid under deposit, recently the Punjab and Haryana High Court followed the Gujarat High Court and Delhi High Court, saying that no deposits can be made during the course of investigation, and it was directed to be refunded to the assessee along with interest. But there again question of voluntary or involuntary will arise, because recently the MP High Court has taken a slightly different view in this context, whether this payment was voluntary or not. And therefore, if the assessee does not lodge a protest, then it becomes voluntary payment, and in that event you cannot seek refund saying that I did not pay it voluntarily. There is another condition called 16(4) as far as the time limit for taking credit is concerned. The time limit for taking credit is concerned, which gives you time till you file your return, that is the September of the next month. So effectively you get from the date of the invoice about 18 months to take this credit. Is this condition valid? Suppose there is a delay in filing your GSTR 3B return. Okay. Because return cannot be filed. Please note, a return GSTR 3B cannot be filed unless you pay the tax. So if I don't have the money, let us say for whatever reason, there are business exigencies, I am not in a position to pay the tax, and therefore I am not able to file the GSTR 3B, and there is a delay. My right to credit gets affected. Am I eligible for credit? Recently, the Andhra Pradesh High Court has held that 16(4) condition is valid, and 16(4) condition is independent of 16(2) condition. It does not override 16(2), and therefore you have to comply with the time limit. Okay. There, the only point that, of course, as His Lordship's Honorable Lord Justice Rajesh Bindal was explaining in the morning, a judgment is as good as the argument. Please note, I am also of the firm opinion, a judgment is as good as the argument. Whatever you put up before the judge will deliver a judgment on that point only. Okay. Therefore, in my humble opinion, this judgment is found wanting on independently whether the time limit provided under 16(4) is violated of 14 or not. 1, 2, whether it is violated of 300A, which though it is not my fundamental right, input tax credit is not my fundamental right, does it become a vested right? Does it become a vested right in me if I satisfy conditions of 16(2)? And can that vested right be taken away by virtue of 16(4)? This point, this argument, these two arguments were never canvassed before the High Court, which we are arguing, and therefore this challenge is still open. Again, Supreme Court in Mohit Mineral, this is one important takeaway is this. Okay. Many people feel GST, one nation, one tax, no? Or at least people say that. According to me, it's not one nation, one tax. It cannot be. Okay. The sovereignty of the state legislature cannot be undermined. And please note, today or tomorrow you will see the true colors of all the states put together. We are not 30 states, sir. We are 30 countries rolled into one. Okay. So each state can do what they want to do. And that day will come. And this is what exactly the Supreme Court in Mohit Minerals explains, that the recommendations of the GST Council, though all the state finance ministers are part of the GST Council, the recommendations of the GST Council are only recommendatory. They are not binding. Though therefore say state of Kerala or a state of Maharashtra or a state of West Bengal was a party to that, they can take a different view. They can have a different view, they can have different rates, they can have different rules, they can have whatever they want to do. And that day will come, sir. Please note, that day will come. It's only 6 years. We have not seen the tribunal in 6.5 years, but that day will come. Okay. Because, sir, please note, this is not something new to us. Okay. When VAT was introduced for the first time in European Union, for the first, they call it VAT, we call it GST. For the very first time when VAT was introduced in the European Union, the majority of the disputes, the majority of the litigation that they saw was whether France will tax it or Germany will tax it. If they can do it, we are masters. We are masters. That litigation will happen. Whether this supply is in the state of Punjab or the supply is in the state of West Bengal. Who will tax it? Because nobody will want to pay IGST, no state will allow payment of IGST. Erstwhile CST, now it will be local tax. And second litigation that you are going to see is input tax credit. Okay. Input tax credit will be denied at every stage, everywhere. Your lorries will be stopped. Today there is no octroi naka, sir. Today there is no check naka. There is no check naka, there is no octroi naka with GST. All have been abolished. Every street has become check naka. They can stop your vehicle at any street, any nook and corner. Bharti Airtel we discussed. Another judgment of Supreme Court important is in Cosmo Films, sir. Here there was a condition of refund. Condition of refund, there was a mandatory condition under the advance authorization scheme. Okay. Under the advance authorization scheme which was struck down by the Honorable Gujarat High Court, the Supreme Court reversed the judgment. Supreme Court reversed the judgment stating that the condition is valid. However, the Supreme Court sent out directions to the government saying that you come out with circulars and allow refunds. Allow these exporters, because they are all exporters. They are all exporters and who were not privy to this condition, and therefore you allow them refund subject to the conditions that advance authorization for the past will not be subject to this condition. Okay. Judgment of this High Court has been, of the Gujarat High Court has been reversed. We discussed Bharti Airtel. Radhakishan again. Sir, there are a lot of provisional attachments. This is in the context Supreme Court judgment in the case of provisional attachment. What do you mean by a provisional attachment? As the word, as the name itself suggests, it's provisional. When is a provisional attachment required? When the tax officer or the commissioner, rather in this case, when the commissioner is of the opinion that it is necessary to do so. In other words, when the commissioner is of the opinion that if an assessment order is passed against you, I will not be in a position to recover this money from you, and therefore I need to resort to provisional attachment, then only provisional attachment can be done. Provisional attachment cannot be done merely because I feel, okay, money is available, bank account is there, therefore I will provisionally attach. Or land is available, therefore I will provisionally attach. Answer is no according to me, and that's what Supreme Court says. Gamescraft. This is important. Everybody is reading, no sir, these days 28% on online gaming industry. Online gaming industry 28%, 28%. Okay. What is this online gaming tax, sir? What is this 28% online gaming tax? They will wipe off the industry only. How? I'll tell you, sir. What the tax seems to be that if I pool in 10 rupees, sir pools in 10 rupees, and sir pools in 20 rupees. So 30 is on the pool, and I win the pool. Suppose I win the pool. I become owner of the 30. They lose 10, he loses 10. I become owner of the 30. On 30, I pay 28% tax. Okay, no difficulty in that, sir. There is absolutely no problem. Tax it. Where is the question? But when I reinvest that 30, and I again win that 30, again I pay 28% tax. So this keeps on going. That is why they are saying 21,000 crore, 30,000 crore. If this were to be right, you don't need any other tax, sir. 2 lakh crore per month will come from this. Bas, aur kuch nahi chahiye. All of you can go home. All of us are out of business. No work. This is good enough. This is good enough. This is pursuant to the Honorable Karnataka High Court judgment which read down, saying that this cannot be subject to tax because it is contrary to the law laid down by the division bench of the Karnataka High Court itself, saying that it cannot be taxed. But now the GST Council has recommended a taxation. I have nothing against taxing it, sir. If you want to tax, you tax the air also, we breathe. They can, sir. Huh? Bilkul. Tomorrow if they want to tax reproduction, they can tax that also. They will make lot of money, sir. They want to tax, they can tax that also. Okay. That's the biggest supply in our country, sir. Okay. I have no difficulty, but the scheme of taxation should be, actually according to me, what they should tax is the entire pool in the hands of the desk. Hands of the desk at the 1% or 2%, whatever. The entire money stands tax. You don't need to have this 28% tax on each transaction in that sense. Okay. Levy of entertainment tax. Recently the Madras High Court upheld the levy of entertainment tax. The argument was that I am already paying GST, but there is an entry for entertainment tax. The Madras High Court took a view that there is an aspect of entertainment also, and there is an aspect of supply also, therefore both can be simultaneously levied. Section 172 doesn't come to your rescue, and the levy was upheld. Okay. So tomorrow if DTPA also, if they subject to you to entertainment tax, okay, because you invited me, there can be entertainment tax on you also. The other judgment, recent judgments of the courts, various courts of Gujarat High Court, Delhi High Court, Bombay High Court have taken during the course of this search, etc. Okay. What do you mean by search? What do you mean by search? Whether in direct tax or indirect, what do you mean by search? When the tax authorities, when the tax officer, whether it is a GST officer or income tax officer comes for search, what do you mean by this search? What is he searching? What is he searching? What do you, no, sir, in legally, I am asking legally, whatever questions I ask is legally. What do you mean by this search? What are they searching? Undisclosed assets means they are searching gold. Are they coming to search cash? Or are they coming to search some person? Some person is not available. They have come to search in your house. Where is your father? Where is your father? Child will say, I don't know who is my father. Please go from here. What do you mean by this search, sir? This is what the Gujarat High Court came down very heavily. The search can be of the documents. Please note these are taxes. This is not a criminal law. Please note they are not police officers. They are not police officers who have come for a search of a person, or where the police comes to know that the contraband or the offending goods are lying in your premises, where they come with a specific search warrant. This search is not like that, sir. This search is for documents, things, which the tax officer feels are liable for seizure or confiscation because they are offending. Therefore, as far as income tax also I'll explain, as far as GST is concerned, sir, what can they search? Everything is available on the portal. All my returns are on the portal, purchase invoices, sales invoice, everything is on the portal. What do you want to see? Documents. Which undisclosed document, sir? Which undisclosed document? If there is no requirement in law to disclose something to the tax officer on the online portal, then it is not required to be disclosed. Then it is not required to be disclosed, sir. Okay. That is not suppression, that is not concealment. Concealment is something that you are required to disclose in law to the tax officer and you don't disclose. That is concealment. Okay. Otherwise it is not concealment. That's true, no, sir? In Mahabharata, when Lord Krishna knew that Ashwatthama ne abhi humko pakad liya hai. So he says that I will go and ask Yudhishthir because Yudhishthir never lies. Okay, Yudhishthir never lies. So Ashwatthama, he asked, Lord Krishna tells Ashwatthama to ask such a question where the answer he knows that Yudhishthir is going to say yes. There is no suppression there. There is no concealment. Because I was not supposed to disclose this information to you. Then there is no concealment. There is no search in GST which according to me, there is no offending goods. Therefore, there cannot be a search of any person. When they do physical search, they cannot touch you. Please note, as far as GST is concerned, they cannot touch you. Or they come and seize your mobile phones. The first thing they come and say, give me your mobile phone. What do? You give your mobile phone. Can they take your mobile phone? Sir, they ask, you give. Tomorrow they will ask, give me your wife, you will give. Exactly, sir. That's the point. WhatsApp, sir. Okay, let me see. You go home, let your wife ask you, give me your mobile, whether you give. उनको कभी नहीं देंगे, डिपार्टमेंट मांगे ले जाओ. क्यों? No, that's what. Is it legal? Answer is no. According to me, answer is no. The laptop, please note, let me put it like this. Laptop with this day and age of technology may be your document database. Therefore, there may be a different opinion as far as laptop is concerned, they may be able to take it. Your mobile phone is your personal accommodant. It cannot be taken away. It cannot be seized. It is not something, documents or things which are part of section 67 search. Okay. Your WhatsApp is not official communication, sir. Okay. It's not official. Okay. I know one search happened in Vapi, sir. One of the clients came to me, sir, client came to me, running to me, saying that, sir, they are paying, say, pay 2 crores. And I paid 2 crores. I said, why? They said, we have found your phone, we will give it to your wife. He said, I'll pay 2 crores, but don't show it to her. Okay. Mobile phone, in my humble opinion, cannot be. Okay. This is what the Gujarat High Court explained in Pareshnath's case and Valerius and other cases. The term search here is very limited. Okay. What happens if it sees cash? Can they seize cash? Can they take away? Suppose they find 1 crore cash is lying in your office. Can they seize it? Answer is no, according to me. As far as GST is concerned, they cannot seize it. Their duty is to call the income tax officer. Their job is to call the income tax officer. Technically they don't. Okay. They have to call him saying that I found this and you have authority, you have jurisdiction to seize it. Saying that this is unaccounted income. And therefore you can tax it. As far as GST is concerned, they have no business. They are concerned with supply. Okay. I don't know whether we have time, sir. I don't know whether we have time to finish all these judgments, sir. Okay. In income tax also, okay, there is a penalty. Most people are worried about penalties, etc. also. Okay. There is a section called 271A, capital A. Okay. They say penalty, if you have a bogus billing, I will impose penalty on you. Recent section you must have seen. How income tax is concerned whether I have a GST bill or no? How can they impose penalty on me? How can they impose penalty on me, sir? Whether I have a fake bill in terms of GST or not, how can they impose a penalty on me? They can say, I have no difficulty. They can say these are unaccounted purchases, therefore I will disallow. I will disallow these purchases. If you disallow my purchases, you disallow my sales also. Then there is no output tax. 2 minutes, just 2 minutes, madam. 2 minutes. According to me, penalties cannot be imposed on this ground, my lords. Okay. According to me, there is no question of imposing a penalty in my submission on this count. Okay. Which one? Last one, sir. That there assessee argued. Assessee argued that 12.5%, this was a case, sir, where, suppose, take a case where genuinely there are 4 transactions which are not genuine. Take a case. Does my entire purchase become bogus? Answer is no. Answer is no. Does my entire sale become bogus? Answer is no. This is what is happening today, sir. If they cancel, if they find that there are no supply, suppose there is one transaction of a particular supplier which is non-genuine. Let us assume for a minute. All his supplies do not become non-genuine. All his supplies to all his purchases doesn't become non-genuine. This is where my problem lies. GST is a transaction-based tax. Likewise, income tax also is based on these transactions. If one transaction is non-genuine, all my purchases don't become bogus. This is what the Bombay High Court held. That if you find that about 10, where party admitted, the assessee admitted, this was a case where assessee admitted that about 12.5% is non-genuine, and therefore this can be disallowed. The question there was, the revenue's appeal was the entire thing has to be bogus. The High Court said no. These are all points which have to be argued, and on these basis notices can be quashed. Only one point that I want to add to what Jagdishar said was, his question was whether 148 AD order, a writ is maintainable or not. Writ will lie or no. According to me, a citizen of this country can complain to the jurisdictional high court saying that there is a violation of Part 3, fundamental rights, irrespective of whether there is any alternate remedy available in the statute or not. And the High Court, with due respect under 226 and supervisory jurisdiction under 227, has power to entertain that writ. Whether it is interlocutory, no interlocutory, whether alternate remedy or no remedy, anything, according to me, please note, can be questioned before the jurisdictional High Court under 226. Whether the High Court entertains the petition or not is a question of entertainability by the High Court in the facts and circumstances of each case. That is a question of discretion of that particular bench. Yes, certainly. But to say that writ cannot lie against something, according to me, no. A writ can lie, a writ is maintainable. Whether it is entertained or not is a question of jurisdiction, is a question of discretion of the bench. And therefore, please note, you can challenge anything under 226. Okay. I don't think we have time to complete this, sir. Okay, I think I have closed in time so that we can have lunch at 1:30, all of us. Okay. And if I have committed any mistake, etc., please pardon me. That's what my junior tells me. My junior always tells me, sir, yes, you go to so many conferences, so many lectures, etc., but itna maza nahi aata hai the way you argue in the court. That is real fun. So I always tell him, fool, there I am getting paid. Thank you very much. Thank you.
Thank you very much, sir. Thank you very much. Now I request Chairman, sir, Senior Advocate Abhiratosh Majumdar to give his concluding remarks, please.
I think we are all running late for the lunch. I don't want to detain you, but I must say 2 words. First, for Mr. Punjabi, his rendition was incisive and insightful. Permit me for using the expression insight, because that is the expression which bothers us most nowadays. And coming to Mr. Rayachandani, I am now a big fan of Mr. Rayachandani. I am really now a big fan of Mr. Rayachandani. I don't know whether we can work together in some matter or where we get paid actually. So I will definitely not miss that opportunity. But it's a wonderful, wonderful rendition, Mr. Rayachandani. It was so interactive, and you took Justice Bindal's speech to its letter and spirit. You made this session as an interactive session. That's the best part of it. That's all. Let's wind up. And writ is always maintainable, sir. An order under section 148D per se as a standalone order is not an appealable order under the Act. Per se, I am saying. It is only subject to constitutional remedies. And the remedy under Article 226 cannot be butted or bounded by any statutory limit. Its law is well settled. There are limitations, but those limitations are self-imposed. That's all.
Respected dignitaries on the dais, distinguished guests, fellow professionals, ladies and gentlemen, it is my honor and proud privilege to present a vote of thanks to Chairman of the session, Senior Advocate Abrutus Mujumdar sir, Speakers of the session, C. Jagdish T. Punjabi sir and Advocate Bharat Rai Chandani sir, for sparing their valuable time out of their busy schedule and delivering on important topics. I am sure that we all have present here have been benefited immensely from the deliberations. Thank you once again, sir. I also thank all the participants, past, present and members of DTPA for sparing their valuable time and attending the first technical session of the annual conference 2023. Lunch is ready. You may proceed for the lunch. Thank you. Thank you, sir.
Thank you, Barka.